right, good morning again. Welcome everyone. We're here on the matter of Holtec International's application to construct and operate a consolidated interim storage facility for nuclear waste in Lee County, Mexico. I should mention that in addition to this room being open to the public, we are making available this proceeding on listen-only telephone lines so that interested members of the public who cannot be here can follow this today if they so choose. I'm Judge Ryerson. I'm trained as a lawyer. I chair the particular Atomic Safety and Licensing Board that the NRC has assigned to this case. On my left is Judge Shakuros, who is a nuclear engineer, and on my right is Judge Arnold. Dr. Arnold is also a nuclear engineer. Today's proceeding concerns 6 hearing requests that the NRC has received, challenging aspects of the application that have been filed by Holtec. And we'll list them by name when we take the appearances of counsel. We also have before us 5 petitions to participate in this proceeding as interested local governments. And these have not been opposed. Before we take the appearances of counsel, I'd like to review how we intend to proceed today. I think we've pretty much set it forth in the order that we issued on January 10th. Again, our principal purpose today is to hear arguments on the hearing petitions to determine whether the hearing petitions meet the NRC's requirements to participate in an evidentiary hearing, which, if it's held, will be held at a later stage. Today's arguments are essentially procedural ones. We also have before us a host of related motions, and they may or may not come up today. We're not going to argue them specifically, but they include motions by some of the participants to strike portions of other participants' pleadings. They include motions to adopt parts of other participants' pleadings. They include motions to file new and amended contentions, both of which I think are pretty closely related to Beyond Nuclear's contention and also Sierra Club's contention number 1. And finally, we have motions addressed to the type of evidentiary hearing we should have if we have a hearing. Now, we have read the pleadings that have been filed by all the participants here. They total literally hundreds of pages. So as we said in our order of January 10, we would like to begin with each individual participant with a brief, I do mean brief, no more than 10 minutes or so, a statement of their position if they wish to make one. But then we'll begin with questions for each participant, one after the other. And I should urge that nobody should feel that we are neglecting them if we do not have many questions for them. In some cases, the pleadings are quite clear, I think, as to what the issues are, what the positions of the parties are, and we simply may not need to feel, to hear further explanation on some of the individual contentions or even the standing issues. So don't take anything, I hope, from the fact that we may not have a lot of questions for a particular participant. That simply means that we believe anyway that we understand exactly what the issues are. When we ask questions, generally the board will be directing questions in the first instance at the petitioner or participant who's in front of the podium. We may, I think we have available mics, remote mics. We may ask another participant to comment. Generally, if we want another participant to comment, we will request that. Nonetheless, I think we'll be relatively informal here. If anyone has an uncontrollable urge to comment on somebody else's response, raise your hand. We may recognize you, but if we don't ask, better in most cases to simply wait your turn. I don't know if we have here, we'll check when we have the appearances, if we have representatives of the local governments, but we will find time to fit in statements by any of the local government petitioners who would like to make it. But their petitions, as I think I said, are not opposed, and so they really don't have to say anything at all unless they want to. Logistics. We will take at least one short break in the morning and the afternoon, perhaps two. We will break for lunch, I think, at the first convenient opportunity after noon. And today we will finish by 4:30. We promised the building that we will have everybody out by 5. So we really should try to wrap up, I think, by 4. People can straggle out and be out of the building by 5. What else? Before we take the appearances, any comments, Judge Arnold, Judge Figueroa? Lunch, I think, there's no cafeteria in this building, so we're probably going to take a relatively long lunch, an hour and a half, so people can not only easily go someplace to eat, but also perhaps have a chance to discuss issues if that's helpful. Anything else, Judge Figueroa? Judge Arnold? Okay. What I'm going to do now is ask the individual council and representatives to come to the podium and identify themselves. If you have questions about what I just talked about, this would be a good time to ask them as well. So let's begin with Beyond Nuclear.
Good morning. My name is Carolyn Reiser, and I will be appearing on behalf of Beyond Nuclear.
Good morning. Welcome.
I don't know if you want each of us to come by ourselves, but I'm Diane Curran. I'm appearing on behalf of Beyond Nuclear, and also with us today is, shall I just introduce her, or would you like her to come up? Mindy Goldstein.
You may introduce them from your podium.
We have with us this morning Mindy Goldstein, Director of the Turner Environmental Law Clinic, also appearing on behalf of Beyond Nuclear, and 2 law students. Alex, what is your last name now? Hears. And Marguerite Mills.
Thank you.
Thank you.
Welcome to all of you. And who will be speaking on this, Karen? Will both of you
Ms. Reiser and I will be speaking. She'll be delivering the opening statement, and I will be answering questions.
Okay. Thank you. The Sierra Club.
I'm Wallace Taylor on behalf of the Sierra Club.
Good morning, Mr. Taylor. Thank you. Welcome. Alliance for Environmental Strategies. I think I have it right. It's appeared 2 different ways in some of the pleadings, but do we have a representative? Yes.
I apologize for the confusion I caused it. I'm Nancy Simmons. I'm here for the Alliance for Environmental Strategies.
Thank you. Welcome, Ms. Simmons. All right. I'm going to refer to them after this moment as joint petitioners, but we have, I believe, 1 council representing, and tell me if I don't have this right, Don't Waste Michigan, Citizens Environmental Coalition, Citizens for Alternatives to Chemical Contamination, Nuclear Energy Information Service, Public Citizen, San Luis Obispo Mothers for Peace, and Nuclear Issues Study Group. I believe that you represent all 7, is that so?
Yes, sir. Good morning. My name is Terry Lodge.
Mr. Lodge, you appear to be what we used to call in private practice a rainmaker, so I congratulate you.
If that is so, Your Honor, I'm drowning. Thank you.
Thank you. Welcome to you. Next is, I think it's pronounced NAC. It's not NAC, but NAC. Is that correct? NAC International? NAC. Okay, thank you.
My name is Sasha Desai. I'm appearing as counsel for NAC International. Along with me is Daniel Stanker from Hogan Lovells Law Firm, also counsel for NAC International, and Robert Helfrich, who is general counsel for NAC International.
Thank you, Mr. Desai. Welcome to you. Welcome to you all. Let's see. Next, and you can satisfy some confusion I have here. Actually, Fasken Land and Minerals and Permian Basin Land and Royalty Owners.
Yes. Good morning, Your Honor. My name is Robert I, and I do represent those parties.
Okay, thank you, Mr. I. The question I had is, I think I'm correct. Fasken Land and Minerals is a member of the Permian Basin Group, but are you representing each of them separately as well?
Yes.
Yes. Okay.
Yes.
Thank you.
Thank you.
Let's see. That's it for the petitioners. Now, Holtec International.
Good morning, judges. I'm Jay Silver at the law firm of Pillsbury Woods and Shaw Pittman, representing Holtec International. Here with me representing Holtec International from Pillsbury are Tim Walsh and Ann Leidick, and we'll all be speaking in response to your questions. I will be delivering the opening statement.
Good morning, thank you, and welcome to all of you. The NRC staff. Who do we have for this staff?
Good morning, Your Honor. Sarah Kirkwood for the NRC staff. I'm accompanied by my co-counsel, Joe Gillespie and Alana Weiss. And we also have with us several of our staff members. We have John McCurgan, who is the branch chief for the spent fuel licensing branch, Jose Cuadrado, who is the safety project manager for this project, and Jill Caverly, the environmental project manager.
Thank you, Ms. Kirkwood. Welcome to all of you. Next, and I'm not sure if we have them all here or not, but we have, as I said, 5 petitioners to participate in any evidentiary hearing that we have one as local governments who have a special role in our hearings under the rules. The first I'll mention is, I may be mispronouncing the county. Is it Eddie or Edie? Eddie Lee, the Eddie Lee Alliance. Do we have anyone? Yes.
Mr. Chairman, my name is John Heaton, and I am the Vice Chairman of the Eddie Lee Energy Alliance.
Thank you, Mr. Heaton. I have a question for you.
Yes, sir.
First, do you intend to speak for a few minutes today? We were certainly entitled.
We would like to. We have 3 members here that would like to speak, and 2 of the county commissions would like to have members to speak. And then one of the members for representing the city of Carlsbad could not be here today because of commitments tonight, but is going to come tomorrow if the hearing goes on. He would like to speak then.
Okay, the second question I had for you was, do you plan to stay, if we go 2 days, do you plan, I know you've come some distance and we could take you today if that matters to you, otherwise we'll put you in.
Mr. Chairman, I think all of us plan to be here for the whole week 3 and the
We'll find a convenient time then.
Yes, thank you.
Thank you. So the city of Carlsbad, are you separately represented, or who? In other words, are you coordinating all of the counties and the cities that are involved?
The city of Carlsbad's representative will be here. He's the individual that will come tomorrow.
Okay.
There's nobody from the city of Hobbs.
No one from Hobbs. Okay. And so Lee County, is anyone here separately from Lee?
Yes. Mr. Jonathan Senna.
Okay. Mr. Senna, did you, I'm sorry. Yes. You're Mr. Senna. Yes. Okay. And you are speaking or not?
Yes.
You are speaking. Okay. And Eddie, or Edie, is it Eddie or Edie? Eddy County, then, I think the appearances were entered by Mr., and I'm going to really apologize in advance for his name, Rudometkin?
That's good, sir. Thank you.
I did get it right.
Yes, sir.
Thank you, sir. And are you speaking independently, or?
Yes.
Okay.
Yes, thank you.
Okay. Very good. Judge Arnold, anything? I'm sorry.
I belong to the group forever. I asked actually the action team, and I don't see Jenny Greenwald here. She's been very active in this and the leader of our group. So if she doesn't come, may I speak for my group?
Have you entered an appearance? Have you filed anything?
No.
Oh, okay. Now this proceeding today is limited to participants, petitioners, the applicant, the staff, and the government entities who have actually filed and asked for an opportunity to speak.
But not the people.
This is a government of the people, by the people, for the people, but you had an opportunity to enter an appearance, and you haven't. So some other time perhaps, but not today.
How could we have entered an appearance?
Because there was a Federal Register notice providing an opportunity to participate, which all of these groups responded to, which 5 different local governments responded to.
So Dave McCoy from Citizens Action, you have to file, you have to ask to speak, please?
I'm sorry?
I'm asking someone from an organization that we belong to. He's been very active, and we really do a lot of, we really support him. I'm just asking him, has he
Okay. 2 things. One, today we are limited to the parties, participants at this point, who have filed pleadings in front of us. That's all we are considering. And Judge Jacoros reminds me, I perhaps should have asked people to turn off their cell phones for the rest of the proceeding. But thank you. I'm sorry we cannot hear you or anyone else who has not yet filed something today. Judge Arnold, before we start questioning, nothing? Judge Jacoros? Yes. All right. Well, we will begin, as our order said, with Beyond Nuclear. So I'm not sure I caught your name. Is it Reiser?
Yes.
Reiser. Okay. And your opening statement.
Thank you.
Thank you.
May it please the board, my name is Carolyn Reiser, and I'm a fellow with Emory Law School's Turner Environmental Law Clinic. I'm appearing on behalf of petitioner Beyond Nuclear. This proceeding that we all participate in today is illegal. This adjudicatory body does not have the authority to review a license application that is based on an illegal premise. Although Holtec presents it as an alternative, the mere inclusion of the Department of Energy as an option to be responsible for the spent nuclear fuel transported to and stored at the proposed facility is illegal. The law is clear. The Nuclear Waste Policy Act states affirmatively that the U.S. government cannot take title to privately produce spent nuclear fuel until a final repository is operational. There is no dispute that no final repository is operational, let alone even licensed. Thus, Holtec's application is based on an illegal presumption, and the application should be dismissed. By conducting these proceedings, the Nuclear Regulatory Commission has impermissibly allowed Holtec to undermine long-standing United States law established in the Nuclear Waste Policy Act. However, regardless of established law, the Commission has directed that this proceeding for the moment will continue. In accordance with that wish, Beyond Nuclear has shown, and will continue to show today, that it both has standing to pursue this claim, and that the Holtec application violates the Nuclear Waste Policy Act. First, as the NRC staff agree, we established that Beyond Nuclear has standing. Our members live, work, recreate, and frequent the fence line of the proposed Holtec facility. They are mineral owners whose financial interests are threatened by the presence of nuclear waste, limiting their ability to extract their resources. They are ranchers who currently ride horses over the very land that Holtec proposes to use to store hundreds of thousands of tons of nuclear waste. They are families whose children pass across the Holtec land every weekday just to get to school. Suddenly their land is no longer pastoral ranch land, as it has been for 100 years, but instead will be overshadowed by the largest nuclear waste dump in the world, lessening the value of the land for any other purpose. Suddenly, just driving on what is essentially their main street, Highway 62-180, will mean consistently exposing themselves and their families to doses of radiation as they drive along this highway on their way to work, to school, or just to see a movie in town. They will be exposed to radiation from shipments of nuclear waste paralleling the highway on the way to the Holtec facility. Beyond Nuclear members will not be able to escape being next to the 173,000 metric tons of spent nuclear fuel that Holtec plans to store in their backyards and ship along their main street. The amount of nuclear waste is more than twice the amount that the U.S. currently has, and more than twice the amount that was proposed to be stored at the Yucca Mountain Permanent Repository. No one will be more harmed than these individuals by the licensing of this facility. If you do not grant them standing, you will be declaring this neighborhood a national sacrifice zone without giving it an opportunity to be heard. Next, Beyond Nuclear has shown, and will show further today, that the Holtec application's central premise that the Department of Energy must take title to the nuclear waste at the interim storage site violates the Nuclear Waste Policy Act. And by entertaining this application, the Nuclear Regulatory Commission violates the Nuclear Waste Policy Act and Administrative Procedure Act. The Nuclear Waste Policy Act is Congress's comprehensive scheme for the interim storage and permanent disposal of high-level radioactive waste generated by civilian nuclear power plants. It is the result of brilliant and wise balancing on the part of Congress that establishes distinct responsibilities for the federal government and private generators regarding spent fuel, with the ultimate goal that nuclear waste will end up underground in a permanent repository. By seeking a license that would allow the federal government to take title to the spent fuel at an interim above-ground storage site, Holtec flouts the Nuclear Waste Policy Act and its important balancing. Holtec attempts to skirt the question of who may legally own the nuclear waste it proposes to store by stating that either the Department of Energy or private owners will be responsible for the spent fuel. But by including an illegal option, the entire application is rendered unlawful. Consider a contract that offers for the purchase of an item, either cash or committing a felony. This contract is clearly unenforceable simply because it includes an illegal option. The legal option does not save it. And even though just offering an illegal option is a fatal flaw, we know that the only real option is the unlawful one. To its shareholders, at press interviews, and in industry presentations, Holtec has always said, and continues to say, that to complete the facility, it is counting on the Department of Energy being responsible for the waste. Just this month, Holtec reiterated that the facility will ultimately depend on the Department of Energy and Congress. We challenge the application's compliance with the Nuclear Waste Policy Act. But the purpose of this proceeding is to consider contentions brought under the Atomic Energy Act and National Environmental Policy Act. Thus, we think that this board has no choice but to dismiss our contention. To protect the integrity of this licensing board and this licensing proceeding, we ask that the board take note of the violations of the Nuclear Waste Policy Act and the Administrative Procedure Act. Thank you.
Thank you. Ms. Curran, are you going to answer questions? Yeah, we're going to ask questions after you. I think. All right, Ms. Curran, I understand your Beyond Nuclear's position to be that we really shouldn't be considering this issue. You wanted the commission to consider the lawfulness under the Nuclear Waste Policy Act of this application. And through the secretary, the NRC declined to do that. I think you have appealed that, correct?
That's correct.
To the DC Circuit, and that is, I assume, probably stayed pending our decision?
We've made a motion to hold a proceeding in abeyance pending further proceedings here. The NRC has opposed our motion and has said it's going to move to dismiss our lawsuit, but none of that has been decided yet.
Okay, thank you. Well, I know that in addition to thinking we shouldn't have this issue, you have raised some questions about whether Holtec really has two options on the table. But for the next couple of questions, let's assume that Holtec's position is, as I believe Mr. Silberg has stated it to be, that Holtec wants to either proceed under an arrangement by which DOE would take title to the nuclear waste, or proceed under an arrangement by which the nuclear power companies would retain title to the nuclear waste. The DOE option we'll call option 1, the power company title we'll call option 2. Now, your position, I take it, is clearly that option 1 raises at least a legal issue contention, assuming that there's a contention here, that we should be deciding it at all. Isn't that a legal issue contention?
Yes.
Yes, okay. Now, suppose Holtec changed its mind, and you needn't leap to your feet, Mr. Silberg. I'm not suggesting this is the case, but suppose Holtec changed his mind and said that, well, we're really going to go only with option 2. Would that solve your problem?
Well, it would certainly address the Nuclear Waste Policy Act issue if DOE were not named at all.
Correct.
And it were similar to, say, the private fuel storage case where everything was done by private licensees.
Okay.
Yes, that would solve that problem, and we may come back with other problems, but yes, that one will be solved.
Thank you. And I recall that in Holtec's pleadings, and I really haven't often seen this, there was a suggestion that neither Holtec nor the NRC staff in their pleadings, I believe, directly addressed the lawfulness of what we'll call option 1, the DOE type position. But Holtec did note that there is the possibility of pending legislation in the Congress that would amend the Nuclear Waste Policy Act. Suppose Holtec, and again, Mr. Silberg, I'm not suggesting you're proposing this, but suppose Holtec said, okay, we will modify our application to say that option 1 is conditioned on congressional legislation that we'll say amends to clarify that the Nuclear Waste Policy Act permits DOE to take title in these circumstances. Will that solve the problem?
No.
No.
The reason being that the current state of the law is that the DOE may not take title to spent fuel unless and until a repository is up and running. And for the NRC to entertain, on kind of a hypothetical basis, an application that might turn out to be valid in the future would be, we think, a gross violation of the Administrative Procedure Act, which does not allow the agency to do more than Congress has authorized. And there's a recent case I would refer you to, and I'm sorry I don't have the number at the top of my head. It's State of New York versus the Commerce Department, I think, and the U.S. Department of Commerce. It had to do with the census and the Secretary of Commerce's addition of a citizenship question to the census, which Congress had concluded. And the judge in that case, this was in the Southern District of New York, issued maybe a week ago, said the Administrative Procedure Act It may seem like kind of it's a basic and boring thing, but it's a statute that kind of maintains the integrity of our government. And if the government, if an administrative agency like the NRC goes about entertaining hypothetical license applications that are clearly inconsistent with government law, then that we would submit is a gross violation of the APA.
I think I can anticipate your answer to my next question. Another purely hypothetical. If Holtec said that it would exercise option 1 only if it went to a court of competent jurisdiction and obtained a declaratory judgment that under the Nuclear Waste Policy Act, having DOE take title and possession would be permissible, that would not solve your problem. I take it.
We would say go to the court first and then come to the NRC. And just bear in mind that Beyond Nuclear's members, and these are the people who contribute to the organization and make its work possible, are people who include people who live near this facility, who do not have endless resources to protest a hypothetical license application. They're spending their treasure to argue about something that may never happen and should never happen unless the laws change. The government, I mean, that's part of the APA, is to be responsible to the citizens of the country who go into litigation because there's a real dispute over laws that are currently in effect, not because there's a hypothetical dispute. This is quite an undertaking for these organizations to do this work. And if we were to, I mean, we have the choice of fighting this application because our members are very concerned about this on the many technical grounds that there are to do it. But we chose instead to say, just our group, Beyond Nuclear, is saying, no, this is not appropriate to even conduct this proceeding at this time. If Holtec were to get a judgment from a court saying this is legitimate under the APA and the Nuclear Waste Policy Act, then we would have to participate because we had that judicial interpretation. I doubt they would get such an interpretation.
I had just one, what for you may be almost a moot question. The NRC staff is not opposing the standing of Beyond Nuclear. I believe you have a member who lives about a mile from the proposed facility, and that is the basis on which the NRC staff would agree that you have standing, or do not oppose standing.
I would just add, we have members that are even closer than that, and that, as Ms. Reiser was saying, they cross the property, they have cattle on the property, they would be going, using the fence line area of the property, so even closer than a mile.
Yeah, so for you, this question is not maybe terribly relevant, but we always appreciate your views, Ms. Curran. You also have members who are relying upon proximity to potential transportation routes. Is that, you're relying on them as well for standing?
I would just want to clarify that we are not relying on proximity standing with respect to transportation.
Okay.
We are relying, our basis for standing is virtually identical to the basis for standing that was found by the licensing board in the Duke, Kojima, Stone, and Webster case that's cited in our brief. And as a matter of fact, there seems to be some standard determination that if you are within 2 meters of a transportation pass, you are going to get a certain dose of radiation. I can't remember how many milligrams it is, but it's exactly the same number in the Duke, Kojima, Stone, and Webster case as it is in our case. And we are saying that this isn't a case where we're saying railroad cars may go by these folks. We're saying there's going to be 500 shipments a year for 20 years of highly radioactive material that are going to go on a railroad line or a road from the main railroad trunk to the facility. And people drive along the road right next to that railroad track, and people go into the railroad yard where these cars will sit and they will be within a distance where they will get a radiation dose, maybe small, but they would prefer to avoid it. It's different from a case where, first of all, we're not saying that's a proximity thing. We're saying that is, we're using the numbers in the environmental report to show that there is an injury to our members. And it's, I think Holtec tried to say, well, the Duke case isn't really good law anymore, but I think if you look at those cases, they're quite different. They, for instance, in the Pacific Gas and Electric case, the petitioners that I represented said, we cited the Yucca Mountain EIS that said if there was an accident involving a cast, people might be affected within 50 miles. And the board said, well, the doses would be minuscule, like, you can't rely on that. But this is really quite different. This is every single day of every single year for 20 years. Railroad cars passing through this area are going to be emitting some level of radiation to the public and onto roads nearby, to people who may be nearby.
All right, well, I thank you for that. I think Mr. Lodge's clients may be, some of them in a slightly different position on that issue. We'll talk to you about that. Judge Arnold, did you have further questions?
Sure did. In your petition, you state that this contention is neither within scope nor material to the findings the NRC has to make. Is that still your opinion?
That's a good question. And before the October 29th order from the commission, I would have said unequivocally, absolutely, because the hearing notice that went out about this facility said that this board was going to look at the Atomic Energy Act and NEPA, and there's nothing in it about the Nuclear Waste Policy Act. The commission's order now adds to the licensing board the responsibility to look at our claims. I think so it's gotten a little more complicated, but I think the issue is still the same because it's the hearing notice that still governs, unless a new hearing notice goes out that says, and we will now entertain questions about compliance of this application with the Nuclear Waste Policy Act. I think you're still limited by the scope of your hearing notice, and the commission did direct you to evaluate our claims in the context of section 2.309, which raises the question, is this material, is this issue in the scope?
And you did file a contention as a precautionary matter.
Yes, we did. Yes, it was a precautionary measure, and we think that the appropriate response for the licensing board is to dismiss the contention for lack of scope, compliance with the scope and materiality requirements, and we would hope you would raise some concern about the APA problems that are raised by the case. We'd love to have your input on that. But we think that you really have no other choice under the framework that you are given.
That was my next question. Under the requirements in 10 CFR 2.309F, contention admissibility standards, would you say that your contention does not meet all of those because you say it's out of scope and not material?
That's right. We had to say that because that's what's true.
So, in your opinion, does the board have the authority to admit a contention where the petitioners say it's out of scope and it's not material?
Well, I think you'd have authority to admit a contention if you thought we were wrong, but I don't see how you could disagree with us. I don't mean to be disrespectful, but I just don't see how anyone could say that the Nuclear Waste Policy Act has any bearing on a typical licensing case, because this really has to do with a whole separate statutory framework.
Okay. One last question on this particular topic. Supposing this board just didn't believe you and admitted the contention, would you have the authority or the ability under the rules to appeal our decision stating that your petition should have been denied? I mean, it's kind of reverse of anything we've ever done before.
I don't believe as an interlocutory matter, if we admitted your contention and found that standing, hypothetically, I don't think you would have grounds for an interlocutory appeal.
Well,
Your hearing petition has been granted in that hypothetical circumstance.
yeah, we might try to make an argument, but I think if you admitted the contention, we would think of some way to go back to the commission. I'm not sure what it would be. But I think that we would consider that a problem that we would address.
Now on to a different topic. To your knowledge, does the Department of Energy currently own any spent fuel or greater than Class C waste?
I would think so, but, you know, the Department of Energy has facilities all over the country with all kinds of material in them.
And in that case, if this license were granted, would the Department of Energy be permitted to store that spent fuel and waste at this consolidated facility?
Well, boy, that's a good question. I would be really surprised, but I suppose that's a possibility and another reason why not to entertain this application. It's kind of opening a can of worms.
Okay, that's my questions.
Dr. Doris.
Yeah, would there be any reason why the DOE could not provide funding for utility ownership or for utilities transporting and storing this material, but not the DOE not take ownership of the spent nuclear fuel?
I suppose depending on what's authorized by the Atomic Energy Act for the DOE to do, if that's within their powers under the Atomic Energy Act, yes, but I don't think that that would solve the problem that Holtec is seeking here, is that the issue of ownership is basically involves a transfer of liability, which is really a huge issue for private licensees. This is a long-term problem, we know. It's taking a long time to license a repository, and it would help private utilities to be able to shift liability for spent fuel from the private licensees to the Department of Energy. And by giving grants to private licensees, that might help them along somewhat. And I have no idea whether that would be legal, but I don't think it would address the fundamental issue here. And that is a transfer of liability. And this was, I would just recommend you look at CLI 02-29, which is a decision by the commissioners about the private fuel storage application, where the state of Utah said that scheme violated the Nuclear Waste Policy Act. And the commission quotes a colloquy about why the Congress wanted to set up the legal scheme this way. Congress was worried that if the Department of Energy took title to spent fuel before a repository opened, that this would dilute the incentive for private licensees to get behind a repository, and that storage would become the de facto solution, which is, you know, a major worry for Beyond Nuclear, that if the Department of Energy becomes involved here through taking ownership, that takes away a lot of incentive to find a permanent repository for this waste. Political incentive I'm talking about. We all agree that there's a tremendous technical need for a repository, but political incentive is very important. And that once New Mexico had accepted basically the entire inventory of spent fuel to the United States in an above ground facility, a lot of motivation to find a repository would be gone.
But as you mentioned earlier, PFS was to be funded entirely by the private sector and did not include DOE at all.
That's correct. But the commission just explained why the private project that PFS had didn't fit within the Nuclear Waste Policy Act scheme.
Thank you, Ms. Garrett.
Okay, thank you.
All right, we'll take a break either during the middle or after Mr. Taylor's presentation. So we'll go next to the Sierra Club.
Thank you. Good morning. The Sierra Club is the oldest and largest environmental organization in the country. We have over 700,000 members nationally and about 10,000 members in New Mexico. We are concerned about the environmental consequences of nuclear power in general, more specifically the problem of highly radioactive nuclear waste. That's why we're intervening in this proceeding. This project that Holtec proposes is without precedent. 173,000 plus tons of radioactive waste brought to one spot in New Mexico. Although the environmental report, even the third revision, still says 100,000 tons. Holtec's pleading said 103,000, or 173,000, so I'll go with that. It will come from all over the country, mostly by rail, sometimes through cities and urban areas, sometimes through farm areas. I'm from Iowa, so I understand that. And we have to look at the consequences of, first, that transportation issue, and also the sheer scope of this project. As I said, it's unprecedented. The PFS, the project that you mentioned, was only 40,000 tons. The Yucca Mountain Geologic Repository was 70,000, or was going to be 70,000 tons. This project, if we take the 173,000 tons, is much, much larger than either of those, and without the protections and safeguards of a geologic repository. That's our real concern, and why we believe that the environmental report and the safety analysis report are deficient. They really don't address the scope and consequences of this project. So we would ask the board to give this case the consideration that the scope and nature of this project demands. Several of our contentions relate either directly or indirectly to the integrity of the containers in which the radioactive waste would be stored at the Holtec CIS facility. For example, contentions 14 and 20 through 24 raise concerns about the safety, integrity, and monitoring of the containers. Contentions 15 through 19 raise concerns about the impact to groundwater from leaking containers caused by corrosion from salts in the ground and other causes. In recently filed responses to requests for additional information, or RAIs, submitted by Holtec, Holtec has said it will revise the SAR to address NRC staff's concerns about testing for and addressing leaking containers. In response to another RAI, 17-14, Holtec has said the potential for cavity enclosure containers, or CECs, wall thinning will be assessed by visual inspection for any corrosion and or pitting on the interior surfaces of the CEC. Because the CEC is a buried structure, degradation of the coating due to abrasion or other external contact during the life of the CEC is not feasible. Thus, inspection of the CEC internal surface serves as a viable method for determining the potential for any wall thinning due to localized CEC corrosion. So they're admitting there could be corrosion. In another RAI 17-12, the NRC staff recognized the presence of salts that could cause corrosion of the containers, a circumstance Holtec blithely dismissed. These RAI responses were just placed on Adams. The accession number is ML19016A481 on January 16th. They will change our contentions or form a basis for new contentions. Obviously, we have not had a chance or time to make an evaluation. 10 CFR section 2.309 allows late filed contentions. One of the conditions for late filed contentions to be recognized is that they be timely filed. Timeliness has been determined to be within 30 days after the new information on which the contention is based becomes available. Sierra Club therefore requests that the record be left open for 30 days from the date the RAI response was entered on Adams to allow us to file new or amended contentions based on the RAI responses. If the board would prefer a written motion, we would ask for 7 days to file that motion.
Let me just interrupt you there. You are correct that although it's not in the regulations, 30 days has generally been ruled to be an adequate period of time to respond to new information. So if you file within 30 days a motion for a new or amended contention, that's sufficient. You don't need another motion 7 days from now. Thank you.
Okay, thank you. As I said, the issue here really is the danger from the radioactive waste being stored. The U.S. Court of Appeals for the District of Columbia Circuit said in the first New York versus NRC case regarding the waste conference decision that even though it's no longer useful for nuclear power, spent nuclear fuel poses a dangerous long-term health and environmental risk. It will remain dangerous for time spans seemingly beyond human comprehension. I think that should give us all pause and encourage all the parties on board to give this case very serious consideration, and I know you will. Thank you.
Thank you, Mr. Taylor. Let me ask you a few questions first about Sierra Club's contention number 1. The first part of that, I believe, is essentially identical to the beyond nuclear contention. Am I correct? In other words, it's challenging the lawfulness under the Nuclear Waste Policy Act of what we called earlier option one, the possibility that is in the application that DOE would take title to the nuclear waste. Am I correct? That's the first part of your contention.
Yes.
But there's a second part to contention one, as I recall. And that seems, if I'm reading it correctly, to more broadly challenge the idea of any away from reactor interim storage facility for nuclear waste. And are you still pursuing the second part of that in light of the responses you received, or have you rethought that?
In our reply, we suggested that the Atomic Energy Act allows the NRC to not allow an away from reactor ISFSI, and of course Holtec through the Bull Creek case and the PFS ruling. But it seemed to me that the Bull Creek case, which upheld the PFS decision basically, was narrowly focused on the argument that the state of Utah was making, that one section of the Nuclear Waste Policy Act didn't preclude the challenge to the AEA authority for the NRC to not approve anyway from a reactor site. So I think if you look at the AEA as we did in terms of what the AEA allows, that it allows approval only for a production or, I forget the other term, and a production or utilization facility. So that's our position at this point.
Okay. But the NRC regulations now provide, I mean, as the NRC has interpreted the Nuclear Waste Policy Act, there are regulations that provide for licensing and away from reactor interim storage facility. And you have not challenged those regulations in the way that a petitioner is required to, have you?
Well, we're not challenging the regulations. As I see it, we're challenging the NRC's jurisdiction. And as I understand it, that's a different thing. That in a challenging jurisdiction, you're not challenging the regulations themselves.
Okay. But let me ask you a couple of questions about Sierra Club Contention 4, which I think on its face, well, clearly your position, as I understand it, reading the whole contention and its support, is that the evaluation of transportation risks was inaccurate. And one particular aspect of that, you cite the Lamb and I believe it's Resnikov study, which is a study that was based on a fire that took place in the Baltimore tunnel in 2001 and analyzed that from the standpoint that that had been a nuclear issue. And Holtec's argument is that in their environmental report, they cite, I believe it was a 2008 plain old supplemental environmental impact statement of the Department of Energy in the Yucca Mountain case. And they point out that that is very critical, frankly, of the Lamb and Resnikov study, which they basically say, A, at minimum, shows that it's a worst case analysis, and B, they would say it's flatly wrong. And they say that you don't grapple with that at all in your petition. I think I'm characterizing their position. What is your response to that?
Well, first of all, Dr. Resnikov, who was our expert for this contention and was also the author of the report that's being criticized. He clearly states that he stands by his analysis and in fact updated it somewhat for the contention.
I'm not sure I saw it updated. Where is it updated?
On page 25 of our contention.
Okay, thank you.
And secondly, I think that, quite frankly, the Holtec is arguing facts which are not appropriate for this stage of the proceedings.
Well, that's, as you know, the NRC does not make merits determinations on contention admissibility. At the same time, the rules are what the Commission has described as intentionally strict. And the Commission has expressed the view that a party must, for want of a better term, come to grips with the application, things in the application. And what I'm asking you is, if as Holtec represents, there are criticisms of Lamb and Resnikoff, and you're relying on it, but you don't address those criticisms specifically, then you still have an issue that merits an evidentiary hearing. That's a two-part question. The first part is, do you grapple with the criticisms, and if not, why not?
Well, I guess I grappled with it, just with the same response I just gave you, that I think Holtec is arguing facts, and Dr. Resnikoff stands by his prior analysis. Secondly, it's impossible to, when you're drafting contingents, to anticipate every challenge you're going to get from the applicant. Well, you should have seen this, or you should have talked about that, and if you have things that are not that easy to find that the applicant may know about, but how are we supposed to, at the contention stage, when it's very early, to say the least, in the proceedings, and with the time limit we have to form contentions, to just survey the universe for everything that might be at odds with what we're contending.
All right, thank you. Let me ask about Sierra Club Contention 8, which is addressed to the decommissioning plan in the application. And did your original petition essentially ignore the fact that Holtec is relying upon a reasonable rate of return on the money that it puts aside for decommissioning? I mean, I think your original contention just missed that. Is that right?
We didn't specifically discuss that, no. We did in our reply, obviously, which I think was appropriate for a reply.
Right.
But it wasn't obvious, to me at least, when I read their funding document, that they were relying to that extent on the interest that would be generated from the fund. And they said up to 3%, so how are we supposed to know exactly what percent they're relying on?
So the application said up to 3%, a real rate of return, I believe. And I could ask Mr. Silver, a real rate of return, I don't know if he has my question is, when Holtec says a real rate of return of 3%, is that 3% above inflation? Is that what a real rate of return is?
Yes.
Okay, thank you. Well, in your reply, and I know Holtec, I believe, says you shouldn't be allowed to make this argument, but you make an argument in your reply that 3% real rate of return is not necessarily realistic. But do you have any, other than your own view, do you have any support for that position, assuming you're allowed to make that argument? But other than your own view, do you introduce any evidence that 3% is not a realistic rate of return?
We just used their own figures, and I think in their answer they said up to 3%, that's where I got that. But, you know, when you only have 7 days to file a reply, you can't go find an economist who can do that kind of analysis now at the time.
Right. It perhaps could have been in the original petition, but it was not. Let me ask you about contentions 15 to 19, which various challenges based essentially on geology. And the environmental report states, and I think I'm quoting it accurately, at pages 1-7, maybe 7-2 as well. There is no potential for a liquid pathway because the spent nuclear fuel contains no liquid component, and the casks are sealed to prevent any liquids from contacting the spent nuclear fuel assemblies. And it further, the environmental report further concludes at 4-47 that there is no viable mechanism for off-site migration. Where do you address those arguments in your petition, or where does your expert address those specific arguments?
Well, of course, the expert we have for the hydrology is not an expert on radioactivity, but if you look at our contentions, I think it's 14 and then 20 through 24, we do discuss the possible causes of leaks and breaches in the containers. And even if you look at the SAR that Holtec submitted in their aging management chapter 18, they list like 6 or 8 causes of container breach, and so they are admitting there that there are possibilities of container breach, and as I said, even these new responses to the RAIs that I mentioned in my opening statement, I think go to the issue of the possibility that the groundwater and the radioactivity can come together and cause pollution of the groundwater.
But do you, the quotes I just mentioned from those pages, do you, either in your petition or in your expert statement, do you cite those specifically? Do you address those specifically?
Not specifically.
Thank you. Judge Burroughs.
In your contention too, the staff answer actually to your contention too talks about the fact that the contention deals with the need.
It's purpose and need, yes.
The need of the project. In the staff answer, they and in your contention, you're focusing on the relative safety of this off-site SVC in comparison to an on-site SVC, which exists now in almost every plant that we have. Would you say that the purpose and need for the project can be supported by everything other than the relative safety argument? The staff points out 5 or 6 very, what I would view as very important reasons for the project, but you were focusing on this relative safety issue. So is that a major part of your argument, or would you need that for that contention, or be satisfied with the staff answer?
I'm never satisfied with the staff answer. Well, sometimes I am. There were a few staff actions I was satisfied with. But the point of a purpose of use statement is to determine the range of alternatives that are to be considered. If, as in this case, Holtec is making the claim that the CIS is safer and more secure than on-site storage, and they're dismissing on-site storage basically, and as a major factor in why they're doing that, that limits the choice of alternatives. They're trying to use the safety factor as a, I believe, key factor in dismissing the on-site storage as a viable alternative, even though they say in the ER, I think it's section 1.1 or 1.2, that the on-site storage is a reasonable alternative, and in fact, in section 4.14 of the ER, they discuss the impacts of on-site storage and find that it's perfectly safe. Well, maybe I'm exaggerating a bit, but they find that it's a safe alternative. So it seems to me that by neglecting the finding of the continued storage rule that on-site storage is safe indefinitely, the Blue Ribbon Commission report that says on-site storage is safe, that they are improperly limiting the choice of alternatives.
Well, in the NRC staff, I should say, response, and let's take it as a given that whether it's in an off-site facility or an on-site facility, those are both options from a safety point of view, which in fact may be true. So, but let's take that as a given. There are many other reasons for a utility wanting to remove the fuel from their site, and a number of them are discussed in the application. I can't point to specific places, but the staff answered a list of, and one, for example, being to get the fuel off the site so they could return the site to a useful for useful purposes. Wouldn't the purpose and need be satisfied then by those other reasons, as opposed to whether it's safer to have it on-site or off-site?
But when Holtec uses the safety argument in its purpose and needs statement, it has to be backed up, it has to be supported, and because they have other possible purposes and needs, doesn't take away from the fact that they are using the safety argument as a major factor in their purpose and needs statement, and they are thereby limiting the choice of alternatives.
Can I go on? You have a series of contentions, basically, I think 15, 16, 17, that's a sort of a group of contentions.
About the groundwater, yes.
About the groundwater and the chemistry of the groundwater. And the staff in response, of course, provided the argument that you can't identify a mechanism whereby, you know, you have a leak and that leak would lead to all these problems. Isn't it true, however, that in a standalone fashion, you're questioning the adequacy of the environmental report and perhaps even the safety evaluation report or the safety analysis report? In your contention, you sort of focused on, you know, what could happen if there's near-surface groundwater and brine present. Wouldn't it be true, however, that if you eliminate all that and just argue, make the argument that you've shown that there's inadequacies in the environmental report, period? Would that be correct?
If I understand your question correctly, you're saying that I could just argue that the environmental report is insufficient whether or not there's any pathway for contamination, is that it? Well, and I think that's true. Certainly when the environmental report addresses the issue of groundwater and subsurface conditions, and they have to do a thorough, complete, accurate job. We have shown through our experts' opinion that they have not. I think it was basically the staff in Holtec that raised the issue of whether or not there was a pathway for contamination. But we do believe that our contentions regarding the possible leakage from the containers does provide that. But I think you're right that just the inadequacy of the discussion of the underground water and subsurface conditions would be enough for a container, which is basically what we were arguing.
In your contentions, let's see, in your contentions 20 through 23, those contentions are dealing with the question of high burn of fuel. The manner in which high burn of fuel is being dealt with in this facility, is that satisfactory to you?
Well, in looking at the Holtec documentation, particularly the SAR, which relies to a great extent on the UMass FSAR, it looked to me like, and I admit I'm not an expert, I'm just a dumb lawyer, but it looked to me like, and our expert has indicated this, that the Holtec documentation doesn't really address the concerns about high burn fuel that Dr. Rippendorf addressed. It appears that they're just assuming somehow or other magically that the fuel will be less than a certain temperature in the container, and that's it. But I didn't really see any justification or a credible support for that in the documentation.
Now, we have questions on this for the other parties, and so this is just starting this issue. All right, so are you saying then that the interim staff guidance, I believe it's 11, Rev 3,
Yes.
talks about temperature limitations, that if you meet those temperature limitations, that you will mitigate any potential cladding failure effects on the fuel. And it does have separate numbers for the high burner fuel versus the low and moderate burner fuel. Are you saying that that's sufficient, or do you feel that that's insufficient?
You mean the staff guidance is sufficient for Holtec to rely upon?
Yes.
Well, the problem is twofold. One is that Dr. Resnick pointed out that the staff guidance 11 version 3 says that each site must be taken on its own facts, case by case, a determination that that wasn't done here. And secondly, as I said, Holtec, it appears to me, has not adequately justified the statement that the temperature will be below the regulated, the guidance standard.
Have you seen the aging management program? I think it was
It's Chapter 18 in the SAR?
Chapter 18 in the SAR, but there's also a separate submittal of it. I forget which attachment it was to the license application. Do you feel that that's adequate with respect to such things as the CEC, as you mentioned earlier? Do you think the aging management program is adequate to accommodate these various effects? It also includes, by the way, groundwater monitoring, including, I believe, for brine. Now, one of the questions that we'll follow up with is if they're only monitoring the groundwater that the ER says is there, and your contention 15, I think, which says that there's probably groundwater that you're not, that is there that you haven't found, it would be relevant. But do you have any comments at all about the adequacy of the aging management program?
My concern about the aging management program is that, first of all, it would, as we said in some of our contentions, the CFC for the UMAX system is based on a design life of 60 years and a service life of 100 years, I believe. The license for the facility, according to Holtec, would be 20 years, and then they hope to get a 40-year extension. That's only 60 years. So what happens after that? The aging management plan, looks like to me, is strictly a voluntary proposal by Holtec based on what the conditions might or might not be 100 or 200 years from now, depending on how long this site has to be used. And there's no NRC oversight as far as I can tell. It looks like it's totally voluntary with no NRC oversight after the licensing period. So that's our concern, that we're relying on Holtec's guess as to what they might need later on. It's totally voluntary. We just don't have the assurance that it's really going to catch problems or to do anything about them sufficiently if they do find problems.
Mr. Taylor, we're not quite done with you, but Judge Arnold has advised that he has a number of questions. I believe Judge Petros has a few more. We've gone almost 90 minutes now. So we'll take a break until, let's say, promptly 10:40, 20:11, and we will resume at that time.
So 10-minute break?
If
I got
Are you on Michelle Marie?
Yeah.
Good thing you guys have to
We're beginning with questions again from Mr. Taylor. If we could have some quiet so Mr. Taylor can be we have one last logistical issue I probably should have mentioned at the outset. For the benefit of our speakers who have to stand for quite a while, I'm not sure if we've been able to use the federal court under the space would have been that much better, but we're making do as best we can. In any event, we have put water out. If any of these speakers, as they come to the podium, would like to pour themselves some water, they are more than welcome to do that. So we're continuing with questions for Mr. Taylor, who represents the Sierra Club. And we're going to start at this point. I think we'll come back to Judge Flores, but we have from Judge Arnold some questions.
On page 8 of your petition, you list the NCFR 2.309F criteria for admissible contention, and that included item 3, that the contention be within scope, and item 4, that the issue be material to the findings the NRC must make. But then as I looked through, I think there was only one of your contentions that actually addressed that it was within scope and material. So what are we to assume about the other contentions that you did not address scope and materiality?
I guess I wasn't under the impression that you had to specifically say that as long as the contentions were, in fact, within scope and were material.
Okay, but your position is they all are within scope and all are material?
Yes.
Okay. Throughout the petition, you make numerous references to the Nuclear Waste Policy Act. Now, do you consider that an NRC licensing board is the proper platform to challenge whether something violates the Nuclear Waste Policy Act?
As Mr. Curran said, that's a good question. In fact, it isn't clear to me. I certainly would defer to Ms. Curran in her argument that this board may have no jurisdiction to decide the issue of whether the Nuclear Waste Policy Act precludes licensing of this facility. On the other hand, the Commission, through the Secretary, clearly said that this board is the proper venue, so I guess we're between a rock and a hard place. But I chose to bring the contention to the board within the 309 proceedings. So maybe the courts will have to straighten that out.
On your petition, contention 1, the challenge to the authority to license the Holtec CIS facility. Now, as I see it, you say that the NRC does not have the authority to license the CIS facility under the Atomic Energy Act, and when you discuss the basis, that's focused on who would hold title to the spent fuel. Now, page 13 of the petition, you cite Holtec stating it would build the storage facility, quote, upon successful completion of an agreement with the Department of Energy and/or one or more utility companies to store spent fuel. Immediately thereafter, you say, all of the foregoing statements by Holtec and its representatives clearly show that Holtec intends for DOE to take title to the waste. So, as concise as you can, why is not option B viable?
The documentation, particularly the ER, does not provide any indication at all that the nuclear plant owners would agree to retain title. If Holtec is using that option as a possibility, they need to tell us, tell the board, tell the commission what basis they have to say that the nuclear plant owners would want to retain ownership of the waste. They have not done that.
And let me ask you this, I asked Ms. Curran earlier. To your knowledge, does the DOE currently hold title to spent fuel or greater than Class C waste?
I don't know off the top of my head. I don't know.
Now, Beyond Nuclear has submitted a petition that has a very similar contention. And I'm just going to state what I see as the difference between your contention and the Beyond Nuclear contention. Now, from what Ms. Curran said earlier, her belief is when a contract has two options for fulfilling some requirement, and one of those options is just plain old illegal, that contract is not valid. Whereas your argument seems to be that there are two options. One is illegal and the other one is just unsupported by the petitioner. Is that how you see it?
I guess I hadn't considered that my contention and Ms. Curran's were different in that respect. But certainly, our main contention is that all the way along, based on what Holtec personnel had said before the application was filed, what they said in the ER, that a DOE would take title, and now what they've in fact said in a recent statement to the public, in a newsletter that went out, that they're depending on DOE, that we believe that the option B, as you call it, that the plant owners would retain title, is not something that the Holtec has substantiated would even be a possibility, and they have not really convinced anybody, to my mind, that that is a distinct possibility.
Now, Ms. Curran also stated that her contention is not within scope and is not material. Now, considering the similarity of two contentions, why is yours within scope and material?
My understanding is that in a 2.309 proceeding, you can always challenge a legal issue. And I believe that's what we're doing here. Whether the board and thus the commission can legally grant a license in this proceeding. And so we see that it's a legal contention that is appropriate for this board to consider.
Contention 2. You challenged the application statement that the CIS is safer and more secure than storing waste at reactor sites. If the ER had simply said that it is safe and secure rather than safer and more secure, would this contention go away or would it still be there?
Well, the inference clearly is in the ER that they're dismissing the on-site storage alternative by saying that the CIS is safer and more secure. And I think that's very clear in the ER.
On page 18 of your petition, you state the purpose and need statement under National Environmental Policy Act is important because the purpose and need statement necessarily dictates the range of reasonable alternatives. Specifically, what alternatives are you concerned with?
On-site storage.
Just, okay. To your knowledge, you were talking about HOS, which is the, what does HOS stand for?
Hardened on-site storage.
Okay. Has that been implemented at any SCC currently?
In Germany.
It certainly is a technology that has been studied and recommended. In fact, we cited Dr. Gordon Thompson's paper on that. I don't know whether it's been implemented anywhere.
Contention 3 also is concerned with the statement that the CIS is safer and more secure. Now, on this contention, on page 22, you state, Holtec, contrary to NEPA, has not established a purpose and need for the CIS project. But when I look at ER section 1.2, specifically purpose and need for the proposed action, I see, quote, many policy makers and stakeholders in the communities that host shutdown reactors want to have the spent nuclear fuel removed to complete decommissioning of the site and to allow for more beneficial uses of the land. Now, that seems to be a purpose and need that is totally independent of that safer and more secure issue. How is that not a valid purpose and need?
Well, as I mentioned to Judge Dr. Carlos, I think it was, when Holtec cites quite significant that the alleged safety and security of the two alternatives, on-site versus the CIS, is made a distinct part of the purpose and need statement, that unfairly limits the choice of alternatives, basically the on-site storage. So I don't think we can, the Holtec can use that as a major purpose and need, and thereby more or less dismiss on-site storage, and then say, oh, well, there are other things that we mentioned too. I think if they use the safety and security aspect, they have to justify it and that they have to live with it.
Okay, contention 4 has to do with transportation from reactor to the CIS sites carrying substantial risk. You state that these risks must be evaluated in the ER, and that ER section 4.9 does not adequately address these. On page 25 of your petition, you provide your estimate of dose to the population following a major rail accident. This estimate is 1,250 times the estimate contained in the ER. You state here, as shown in Dr. Resnikoff's declaration, the updated estimate of approximately 20 million person REM due to a major rail accident is approximately 1,250 times Holtec's estimate. I looked at the Dr. Resnikoff's declaration, and it was a one-page declaration that contained no calculations or numbers, only the statement, "I have performed calculations and analysis sufficient to reach opinions and conclusions regarding safety issues inherent in Holtec's proposals." Did I miss something? Was there another paper that I...
What Dr. Resnikoff's declaration said was that he had reviewed the contention which he helped draft, and that he is adopting that contention as his declaration, basically.
Okay. So basically we have a conclusion without any numbers behind it. I got it. You fault the environmental report for its reliance on the generic environmental impact statement of continued storage of spent nuclear fuel, and that is New Reg 2157. You have several reasons for that. One of them is the GEIS assumes a consolidated facility of 40,000 metric tons of spent fuel, not for 100,000 tons. What I want to know is, how does the amount of spent fuel sitting at the destination affect the risk of transportation?
The more fuel you have at the destination, the more transportation trips there are going to be, unless the risk increases.
Okay, it's simply, it's a multiplier.
Right.
100,000 versus 40,000, the risk would be 2.5 times greater.
Well, I don't know if it works out quite that way, but yeah, it would be much greater, yes.
The GEIS assumes a dry transfer system at the destination storage facility. How do the facilities at the end affect the risk during shipping?
I think probably that was not exactly addressed to the transportation. It was more to dealing with the waste once it's out there.
Okay. The GEIS does not account for deterioration of the railroad infrastructure. Now, what evidence is there that this deterioration and the actual railroad infrastructure is in worse condition than assumed in the GEIS transportation risk analysis?
What we noted, first of all, in our standing declaration that the rail system, at least in New Mexico, is deteriorated. We noted two recent, at that time at least, rail accidents that were caused by deteriorated infrastructure. So that's the basis.
But hasn't there always been rail accidents?
Well, not necessarily.
Are you? Yes. Does the evidence show that there's recently more accidents than in the past, for shipping oil?
But Dr. Resnikoff in the contention notes that there have been more rail accidents and more rail fires.
Okay. Petitioners fault environmental report section 4.9.4 due to its reliance on the FEIS for the ISPC in Toole County, Utah. And that would be New Reg 1714. And the petition states that this EIS focuses on local transportation and is irrelevant for cross-country transportation. Is there anything wrong with using that EIS for local transportation in the region of the facility?
I think when you try to equate two separate situations, you're taking a risk, I guess, you're taking a risk that the case-specific situation may be different, and you need to be really careful and using another EIS to just determine what should be in this EIS.
Contention 6, the discussion of the no action alternative, you claim it does not consider adequately the on-site storage again. Would implementing HOS at current ISTACs actually be a no-action alternative? It seems to me that would require a licensing action in and of itself.
It would be a no-action alternative concerning this project, because this project weren't built. The on-site storage supplemented by HOS would be a viable alternative. But it would be no action in terms of this licensing procedure.
Okay. And implementing HOS at existing ISTACs, you would admit that it would not achieve the goal of having an ability to return decommissioned sites to natural state, but then you also say that that's not a reasonable need for it because it's limiting the selection of alternatives, right?
The fact that they're dismissing the on-site storage, I think, is a violation of purpose and need statement, or at least what it should be.
Contention 7. Actually, the way I read it seemed to be two contentions. One was Holtec's ER sections 1.1 and 2.1 mischaracterize both the Blue Ribbon Commission's reports, conclusions, and the relative risks of CIS versus on-site storage, and 2, the EIS must independently and fully address the relative risks and benefits of both storage options. That's what I seem to get out of it. Question. You cite ER sections 1.1 and 2.1 claiming that in them, Holtec says the, quote, purpose and need is dictated a great extent by the BRC report. That's what you say. Now, I see ER section 1.1 providing history and background, and section 2.1 discusses the no action alternative. And it is section 2.1 that provides the purpose and need. So I'm wondering why we should give more weight to inferences derived from sections 1.1 and 2.1 instead of just reading the explicit purpose and need provided in section 1.2.
Well, we have to read them together, and I think, I can't think the exact sections at the moment, but there are several places in the ER where Holtec refers to the Blue Ribbon Commission report, and that this proposed project would be consistent with and support the BRC report.
Contention 8. The state decommissioning plan submitted by Holtec does not contain a funding plan that provides reasonable assurance that funds will be available to decommission the CIS state. Now, I looked in the Code of Federal Regulations for the requirements, and it's 10 CFR 72.30, and in paragraph B, it requires a decommissioning funding plan that must contain, and there's a list of things that must contain. The first one is information on how reasonable assurance will be provided. So it makes it sound to me as though the application doesn't have to supply reasonable assurance, just information on how it's going to be supplied in the future. Do you read that differently than I do?
I do. I think that certainly, if that means anything, it means we need to see in the documentation some assurance right now that there is a funding plan that will assure adequate funding for decommissioning. Otherwise, I can't see how that really means anything.
Item 4 in that list of what it contains is a description of the method of assuring funds for commissioning. Now, that doesn't sound to me like a detailed funding plan, but just kind of the words of, we'll use this. Well, basically the funding plan that's in there has a lot of contingencies, and it's not one specific plan. Do you object to the way it's worded now with contingencies?
I think that if there are contingencies, they would have to be very specifically stated and still give some assurance that there will be adequate funding for decommissioning.
Okay. And then there's an item 6, and this one I'm confused on. The decommissioning plan must contain a certification that financial assurance for decommissioning has been provided. Now, I see your challenge being more challenged to this, that there's no certification that the financial assurance is there. Would that be a correct interpretation?
Well, that's certainly an important part of it, yes.
Contention 9. The ER must examine the environmental impact of the containers being used beyond their approved service life. Now, I look at 10 CFR 51.23b, which is the continued storage, and in relevant part it says, the environmental reports are not required to discuss the environmental impacts of the spent nuclear fuel storage in an ISPC for the period following the term of the ISPC license. Now, I believe that these canisters are certified for longer than the ISPC license. So how can I not consider this contention to be a challenge to this rule?
The continued storage rule is based on several assumptions that we've set out in our contentions and our reply. In terms of the quantity of waste, the rule is based on 40,000 tons. This is over 4 times that much, I guess. It's based on having a dry transfer system, which there's no indication in this one that there is. There is no indication in the continued storage rule that it actually considers the problems of high burnout fuel. So all of those assumptions that upon which the rule is based are not present in this case. And as I said in my reply as well, the continued storage rule still provides for site-specific considerations, which we need to look at here, based on those assumptions that are not present here, but that were used in creating the rule. You know, it's like you buy a can of vegetables at the store, and it says the expiration date is such and such. After that expiration date, you know, a lot of things go into whether or not you can still eat that a can of vegetables or not. It may be okay, maybe not, and we need to look at the specific can of vegetables to determine.
Well, Are you therefore saying that the continued storage rule only applies to ISPACs that match exactly the ISPAC used for the study which developed the GEIS for continued storage?
Yes, I believe that if you look at the GEIS, it says it's specifically based on those assumptions.
In that case, one of the assumptions was the dry transfer facility. And I know in one of your contentions you mentioned that there are no dry transfer capability at any ISPACs. So basically, you believe the GEIS and that rule applies to no storage facility current in the United States?
Well, if they had GEIS, it might apply, but there's no indication here that the Holtec plans to have one.
Contention 10. NRC regulations specify that greater than Class C waste must be disposed of in a geologic repository licensed by the NRC. So you're saying that the spent fuel storage facilities are licensed under 10 CFR 72, and in 72.3, an ISPAC is defined as a complex designed and constructed for the interim storage of spent nuclear fuel, solid reactor-related greater than Class C waste, and other radioactive materials associated with spent fuel and reactor-related greater than Class C waste storage. So since the regulation says that this greater than Class C waste can be stored, why must Holtec treat this as disposal of greater than Class C?
Because, as I said in other contentions, this may, in fact, end up being a permanent facility if there's no geologic repository ever created. And frankly, I'm speculating for a little bit, but if this facility is licensed and also one over in Texas is licensed, that may take the political pressure off finding a permanent repository, which would further support the idea that this may in fact become a de facto permanent repository. And as I indicated in my reply, if you look at the definition of the disposal, it would apply to this if in turn, if it in fact is not just interim. And so that's what we were suggesting there, that there's no indication that this will just be an interim storage facility. It may be a disposal facility and therefore cannot accept the GTCC waste. Okay.
Contention 11. Both the ER and the SAR are inadequate in that neither evaluates the potential for and consequences of an earthquake. On page 44 of your petition, you state regarding oil and gas drilling, this drilling activity makes the underground area unstable and induces earthquakes. Now, do you have support for that statement? That this oil and gas drilling does induce earthquakes? I didn't see any support.
Yes, that Stanford study that is attached and exhibits support that.
Now, did that just conclude that it caused more earthquakes, or did it affect the severity of earthquakes?
They were finding new faults as a result.
Well, in SAR, okay, on page 47, you state the SAR 2.6 refers only to historic earthquake data. Is there any earthquake data that is not historic, or were you saying they should be looking at analysis as well as historic data?
I mean, certainly analysis would help, but the data was certainly more remote than the Stanford study that we provided and the evidence of recent gas and oil fracking.
Contention 13. The credibility of those portions of the ER prepared by Tetra Tech is in question. Now, on page 52 and 53, you discuss a petition to the NRC pursuant to 10 CFR 2.206, asking the NRC to revoke Tetra Tech's license. Now, I didn't see any. Did the NRC revoke Tetra Tech's license or put any limits on their license?
The last thing I had at the point that we filed the contention was that the NRC had fined Tetra Tech $7,000 and found that Tetra Tech engaged in a deliberate falsification of soil sample surveys. At that point, the 2.206 petition had not been finally decided.
Oh, do you know if it has now? Or?
I don't know for sure.
Contention 15. The ER fails to adequately determine whether shallow groundwater exists at the site of the proposed CIS. Let's see. 10 CFR 51.45 requires the environmental report for an ISPAC contain a description of the environment affected. Now, how would the site affect the groundwater? Or are you is it you're worried about the site affecting the groundwater or the groundwater affecting the storage facility?
I think the primary focus, although the questions that you gave us before the hearing triggered another alternative probably, is that that may run both ways, but originally our concern was that a leak or a discharge from the facility would impact the groundwater. But I suppose drying in the groundwater could also impact the facility.
Contention 16. The ER does not adequately address basic questions regarding the subsurface movement of brine. This is another similar question. Are you worried about the brine affecting the facility or the facility affecting the brine?
The brine affecting the facility, and it goes to the RAI that I was mentioning in my opening statement.
Okay. Contention 19 about the Packard tests to estimate hydraulic conductivity were not conducted properly. Now that's a way of measuring the hydraulic conductivity. Can you tell me how has the hydraulic conductivity been used in the application? Do they specifically make calculations using the results of the Packard test?
What the contention says, based on Mr. Rice's report, is that GEI consultants who were hired by Holtec to conduct Packard tests at the site To determine the conductivity, GEI claimed it had used the testing method set out in the U.S. Bureau of Reclamation Field Manual. And as Mr. Rice notes in his report, GEI does not appear to have followed several recommendations in the manual.
But what I want to know is, have they used the results of the test in any significant way in the application? Or is it just a number that they had available?
I can't tell you that specifically.
Contention 21. There is no experimental support for the safe transportation and storage of high burnout fuel. Actually, I don't have a question on that. Good. Quickly on contention 23, Holtec has not described how degradation that leads to gross rupture of fuel would be detected. Holtec has not specified how it will address the safety issues inherent in the gross cladding defects due to high burnout fuel. Do you know, is there somewhere a requirement that a storage facility be able to detect gross failure of fuel clad?
Well, we're basing this on Dr. Resnikoff's input, which is in the contention. But certainly, failure of fuel or failure of cladding will certainly be a safety issue. And I don't think we can disagree with that.
Well, when we get to Holtec's turn for questioning, we'll ask.
Okay.
Contention 24, neither the Holtec ER or SAR contains sufficient information to assess the risk of shipping the MPC 37 canisters. And my question is you state specifically insufficient information to assess the risk of shipping the canister. I get from that there's an assertion that the ER or the SAR are required to provide sufficient information for an independent assessment. Is that your statement, or?
Well, sure. I mean, that's the purpose of the ER, and then, of course, the EIS later on. But certainly, there's an NRC regulation on how the NRC is supposed to prepare the EIS, and the first thing they look at is the ER. And so they have to start there, and certainly you want enough information that, first of all, the NRC, in preparing the EIS, can evaluate the situation, and then the whole purpose of NEPA is for the public to be informed. Except that the public is, these calculations to evaluate the integrity of a canister during a shipping accident, that's a detailed calculation that I can assure you most of the public can't make. But I mean, no matter how many details they have. Well, me either. But if the information is not there, a member of the public cannot have an expert like Dr. Resnikoff or somebody else make that calculation who's capable of doing it.
And I'm to the end of my questions for you.
Thank you.
Dr. Carl, do you have some comments?
Yeah, I think so. respect to contention 16, there's a reference to the Rice Declaration where it talks about the presence of brine, but it doesn't talk about corrosion. Is that correct? You're not relying on the Rice Declaration for an argument of an expert witness on corrosion, right?
Right. We're relying on the other contentions where Dr. Riddick talked about the danger of leaks from the canisters.
In contention 17, you talk about fractured rock, and you say these fractures could allow radioactive leaks from the CIS facility to enter groundwater, or for the brine described in contention 16 to corrode the containers containing the radioactive material. And that's really all you say about it. It wasn't clear to me if contention 17 was the environment affecting the canister, or the canister affecting the environment, or both, I suppose, for that matter.
Again, I think it probably goes both ways, but at the time, the emphasis was on leaks from the canisters entering the groundwater through the fractured rock.
But in all of this, you've never identified a leak scenario, right?
Well, as I say, we have in the contentions regarding the safety of the containers. But Mr. Wright was not an expert on that, so he was just talking about the underground conditions that would be impacted or would impact if there were a leak.
Contention 20. Is this a contention of omission in your evaluation? The ER does not discuss specifically discuss high burner fuel.
Yes.
So you consider that a contention of omission? Yes. And how would you expect the subject of high burner fuel to be discussed in the ER?
Well, just the way Dr. Renikoff did, that the high burner fuel could cause cladding failure. There has to be information about how it's packaged in the containers and that kind of thing.
And the existence of a high burner fuel aging management program, an aging management program specific to high burner fuel, that which I think is a SAR issue, is not adequate. You think it should also be discussed in depth in the ER?
I don't know that it need to be discussed in the ER, although I think it certainly could be.
Well, we just discussed that it's a contention of omission, therefore the ER. Yeah. You meant it that way. Yeah. Okay. Contention 21. It says the staff recognizes that data is not currently available. This is talking now about high burner fuel. The staff states that until further guidance is developed, the transportation of high burner commercial spent fuel will be handled on a case-by-case basis. And that's quoting from the ISG 11, I guess. Holtec has not met this test. High burner fuel should not be transported until Holtec can assure it is safe. And then you go on to say the ER must address real-life accident conditions based on the specific facts of this case. And my question is, how does the first part of that apply to the Holtec application? And what's the difference between hypothetical accident conditions and real-life accident conditions? This is not the first place that I've seen this. I think you've used it in more than 2 or 3 places, actually. Why don't you address the hypothetical versus real life first?
As I understand what Dr. Resnicoff was saying is that there could be models, for example, or maybe something taken from some other situation like we were talking about, the PFS EIS being used for this proceeding, versus using data that would more accurately mirror the situation that we have here and the facts that we have in this case. That's my understanding.
So you're saying that what you define as a hypothetical accident condition is a computer code?
Yes, I think that's what Dr. Resnicoff had in mind.
And that wasn't clear. And the other, what you refer to as a real-life condition, is an actual physical test along the lines of Part 71 requirements for transportation testing. Is that?
I don't know if it needs to be quite that elaborate, but that's certainly something toward that nature, yes.
And your position, and I think you said this earlier, this case-by-case business that's discussed in the interim staff guidance, you're claiming that hasn't been fulfilled by Holtec. Right. And until that does get fulfilled, you're claiming that high burner fuel should not be transported.
Right. Or at least Holtec needs to make a better showing of how they're addressing the high.
When you talk about transportation, I'm referring now to your contention 22. Are you talking about the initial transportation to the facility from the reactor site? Are you talking about transportation after a long period of time to the permanent disposal facility? Or sort of all, and also there's transportation within the facility itself, which certainly is a concern to people. Are you talking about one or all of these?
Well, to a certain extent, all of them, but I think primarily the transportation from the reactor site to the facility. But you're correct, there are certainly issues in all of those, but I think probably the biggest risk, of course, is the longest distance of transportation, which would be from the reactor site to the facility.
And the concern with high burner fuel that we've been discussing is transportation related. Is there also a concern with high burner fuel for lengthy storage?
Yes, as I understand it, there can be cladding failure and other problems that don't manifest themselves initially, but with time would appear. That would probably be caused by high burner fuel.
But overall, with all these things we've been discussing about high burner fuel, there really is no satisfactory discussion in the environmental report or even the SAR regarding this subject.
Right.
And you make that assertion in not just one contention, but 3 or 4. I think actually at least 4 contentions, 20 to 23 in general, is discussing that subject.
The high burner fuel, yes.
Right. Okay. So one other item. We have a design, we have a license life, we have a design life, we have a service life. And I'm sure the staff could give me details about what each of those are relative to each other. But would it not be true that you can't get to the design life, or most certainly not to the service life, which is longer, unless you do license renewals of the initial license? So that, for example, if you have X years of initial license and you want to renew that for 40 years, we have to go through this process again. We have to go through a license renewal process, which I believe would include all of the environmental reviews, safety reviews, etc. So this idea of long-term is going to be revisited again more than once, correct?
Well, as I read Holtec's environmental documentation, both the environmental report and the SAR, they're talking about the initial 20-year license period and one 40-year extension. They don't talk about anything beyond that. And then they go into the aging management program, which is, as I said, expresses a concern to me because there's no regulatory oversight. It appears.
Well, perhaps I will ask the NRC this question, but it seems to me you can't go beyond the 60-year point without a license renewal. So, what I've said regarding the revisiting this entire thing would have to occur. Can I? Does the staff want to comment on it?
I apologize. Could you clarify your question?
Right. Each of the stages of licensing requires a detailed environmental and safety analysis review. We're now dealing with the initial license, but if they did apply for the renewal license term, which is 40 years, we would require this process to be repeated at that point, correct?
Yes, sir.
And that would also be true of a second 40-year license renewal.
Yes, sir.
Okay. So there is no way to get to the service life without at least two more license reviews, environmental and safety.
Are you just answering me?
Yeah.
Okay, thank you.
Thank you.
The projected life of this facility is only 120 years. As I read the Holtec documentation. And again, as I said, I don't see any indication that they plan to get a license after 60 years, which, you're right, that creates a certain contradiction. But I think it's up to them to clarify that. The burden's on them. But what happens after 120 years? If there's still waste there that haven't got a permanent repository, I think we just have a lot of questions and problems here that haven't been addressed by the Holtec documentation that your question certainly raised.
Well, perhaps we will ask that question of Mr. Silver when his time comes, rather than do that now. But it is sort of an interesting question. But clearly, every renewal will require a detailed environmental review and safety analysis review, and there will be some board, most certainly not us, discussing that at that time, and you will have all the same opportunities. Thank you.
Thank you.
Just one more question, at least from me. Just a follow-up question on contention 4, Sierra Club contention 4. Judge Arnold made a statement that, speaking, I believe, of Dr. Resnikoff's declaration, that there are no numbers in it. And I want to clarify, my understanding of your position is that Dr. Resnikoff has submitted a sworn declaration or a declaration subject to penalty of perjury that asserts that he has read the contention that you have signed, and that he in fact partly drafted, you say, but in any event, he's read that, and subject to penalty of perjury, he is adopting your language. He is adopting the language of that contention, which contains numbers. Now, we may decide that the analysis in the contention that leads to those numbers is adequate or inadequate, but those numbers are incorporated into his sworn declaration. That's my understanding of your position.
He and I worked on the contention together. I drafted the contention, sent it to him. He said it was fine, and he signed the declaration adopting that contention.
Okay. That's just, if you're not familiar, that was an issue actually that came up in the Yucca Mountain contention admissibility phase, in which both Judge Kuros and I were on 2 of the 3 boards. And that was, we adopted the view that as long as there is a sworn declaration subject to penalty of perjury, incorporating the language of the contention, that is adequate. That was challenged by the DOE, but all 3 boards went the other way on that, and the commission affirmed. So I think that is a practice that is permissible. You've got to have your analysis either in the sworn declaration or in the contention adopted, or both. So it doesn't work if you don't have it either place. But it's okay to have it either place if that is the situation. All right. Any Dr. Arnold? It is now about 11:45. So I think we might as well take an early lunch. And as I said, we'll take a fairly long lunch break. Get out of this building. We can find places to have lunch. And let us plan to resume promptly at 1:15 for the second session.
Diane?
We are back on the record.
Are you with Aphids?
And we're going to begin this afternoon session with a brief announcement. I think, is Ms. Curran here? Where is Ms. Curran?
I'm here, I'm sorry.
Ah, here she comes. All right, no rush. Wait.
They were searching my back.
After the morning session, there was a brief discussion off the record about some scheduling issues, and there appeared to be agreement among the parties. Ms. Curran's going to announce what that is, so it'll be on the record if anybody objects. They're here to object, but absent objection, we will set the schedule issue.
I'm going to step in for
Oh,
Diane, if that's okay. Hi, Mindy Goldstein, good to see y'all. So the proposal is that joint petitioners would amend our motion by February 6th. Holtec could respond by February 18th, and then we could reply by February 25th. And obviously, the NRC staff could reply as well.
And I'm sorry, this is which motion?
The motion to amend our contingent, as well as the motion to strike certain motions. We're going to, the joint consolidated motion.
Okay. Is that clear to everyone? Any objection?
And then we're having the dates February 6th, February 18th, and February 25th.
Hearing no objection, that is so ordered.
Thank you.
Thank you.
Thank you.
All right. Now, I have a question. Mr. Eaton, Mike, I have a question for him at this point. This might be a good time, Mr. Eaton, for a little change of pace to hear from the local government petitioners, if that makes sense to you. I know the city of Carlsbad plans to talk tomorrow, and I don't know if you're in a position to tell us how much time all collectively all of the other local governments would like.
I would guess each statement's in the 4 to 5 minute range, maybe 6.
Excellent. Well, if it's agreeable to you, I think we might do that now, and then that is done with. So please announce as each of you come up for the record, and we'll just go through those. So, Mr. Eaton, you represent the Alliance?
I represent the Eddie Lee Energy Alliance. So, Mr. Chairman and board members, again, my name is John Eaton, and I am presently the Vice Chairman of the Eddie Lee Energy Alliance, and I am designated as their representative to the ASLB hearing. So, our alliance is a long-standing consortium of the cities of Carlsbad, Hobbs, and Eddy County and Lee County, and has been in force since 2006. The proposed interim storage facility site is located approximately 35 miles from Carlsbad and Hobbs in a very sparsely populated area that is very remote. Our cities and counties in the Alliance were strongly supported in the development of the Global Nuclear Energy Partnership, if you can remember back that far. And the project was that project was for advanced nuclear fuel and reactors, and we purchased approximately 1,000 acres at that time to supply an application. We had the site characterized, and we were one of the finalists, but the project, as you know, was subsequently stopped. Then, when Consolidated Interim Storage was proposed, we realized that we thought we had, this was a perfect opportunity to use that land because we believed we had a very superior site. The CISF will have a real impact on our communities. We expect that it will bring with it the following benefits in our member cities and counties. It will create, we believe, 215 high-paying jobs for our citizens. This is a real economic development project in that it brings dollars from outside our area and outside the state into our area. It will diversify our economy of the area which is highly dependent on the extractive industry. Furthermore, we have discovered the presence of engineers and scientists associated with our nuclear projects improves the expectations in our communities for our student educational attainment, the arts, recreation, culture, higher education, and frankly, all aspects of life. We are familiar with living near a site for nuclear and waste disposal, as our city members are located approximately 30 miles away from the existing waste isolation pilot plant, or WIP as it's known, facility run by the Department of Energy. This facility has brought enormous benefits to the region, some 1,200 jobs, and approximately a $400 million annual budget. Urenco, outside of Eunice in Lee County, has also been another stabilizing nuclear business with a multi-million-dollar construction budget, and they have some 400 permanent employees. We have taken the additional steps as the Alliance to become familiar with the nuclear industry by visiting nuclear power plants to see the various dry storage systems, dry storage manufacturers, attending and speaking at industry conferences in the way of waste management and other conferences that have gone on around in the country. The Holtec high store system stands out clearly as being head and shoulders above any of the others from a safety, security, and durability perspective. Our constituents support the Holtec interim storage facility, and we are aware of that because of numerous resolutions that have been passed by our city and county elected officials, as well as resolutions from our chambers of commerces and from our economic development associations in our area. So there are some, at a recent scoping hearing in Carlsbad, there were some 40 members that lined up to speak from Carlsbad. So some of them didn't get to speak, but we were there to speak. We are here today to show our support. The Holtec CIF is a great project. It is desperately needed in the country. The subsurface concrete facility is a virtual fortress. The 1,500 foot thick salt layer under the facility forms an impenetrable barrier to transmission from above it, and it buffers any seismic impacts from drilling or fracking below it. I don't know how it could be made, really frankly, any more safe. Holtec is a great corporate partner that has lived up to every promise without fail, and we welcome the project and the other benefits that it will create. Board members, in closing, we live there, we work there, our children live there. You have certified the system, the high storm system, and we are confident in the geology and our ability to respond to emergencies. After all, we do that with WIP and Urenco, and we are tired, frankly, of all the what-ifs and what if this and what if that, with no real technical basis. We have every confidence in your technical determination process and the capabilities to evaluate the safety of the project. And again, it is a great project. Thank you for your time.
Thank you, Mr. Lee. Who would like to speak next for the local government?
Good afternoon, judges, ladies and gentlemen.
You are Mr. Rudametkin?
Rudametkin, yes, sir. Okay. Thank you for this opportunity. Hello, my name is Rick Rudametkin, and I am the county manager for Eddy County, New Mexico. And I have been designated by the county commission to represent Eddy County, New Mexico at this ASLD hearing. Our county has a present population of around 70 to 75,000 people and is a member of the Eddy-Lee Energy Alliance, which is a long-standing consortium of the cities of Carlsbad and Hobbs and the counties of Eddy and Lee, formed under New Mexico's Local Economic Development Act, LEDA, in 2006. Additionally, our county is adjacent to Lee County and our main city of Carlsbad is located approximately 35 miles away from the proposed Holtec High Store Consolidated Interim Storage Facility. The CISF is also located very close to the Eddy and Lee County line. It is my firm belief that the proposed Holtec High Store Consolidated Interim Storage Facility will be constructed with the utmost care and will deliver many years of trouble-free service as one of the premier facilities in the whole world. Our county has been keenly interested in the development of the Holtec site since the 2013 report from the President's Blue Ribbon Commission recommending that a consolidated interim storage facility be established. We are the perfect and have, in my opinion, the perfect location. With our partnership with WIP, which is our Waste Isolation Pilot Plant, we have a great understanding of the workings of a holding facility and welcome with open arms this new facility. The CISF will have a real impact on our communities, as stated before. We expect that it will bring with it the following benefits to our county and the cities within, just to name a few. It will create and foster directly and indirectly more jobs for our citizens. It will help raise local wages by providing top quality jobs and the best candidates for those jobs. It will generate tax revenue dollars for our county and communities, thereby improving our schools, infrastructure, and our quality of life. It will raise property values and encourage new construction so our communities can thrive. It will add to the economic development and vitality of our diverse county as it continues to grow and expand. As stated above, we are very familiar with living near a site for nuclear waste storage, as our main city of Carlsbad is located approximately, like we said before, 30 to 35 miles away from the existing WIP facility run by the Department of Energy, which has brought many benefits to this region. We've also taken additional steps to become familiar with the nuclear industry by visiting the WIP nuclear facility many times, attending meetings at the Nuclear Regulatory Commission, the NRC, and attending local meetings with the NRC for this particular project. We are also familiar with the San Onofre Nuclear Generating Station in California, which provided me, myself, information and familiarity with emergency response procedures. Our constituents support the Holtec CISF. We know that because of past town hall meetings, general belief in our industries, support of the current WIP site, and a general desire to have a climate of economic development, vitality, and security for our future. We are here today to show our support for this wonderful project. The Holtec CISF is welcome near our communities, and we look forward to the jobs, tax revenue, economic development, vitality, and the other benefits that this project will bring and create. And with that, Your Honor, I appreciate the opportunity.
Thank you, Mr. Berman. Mr. Senna.
Your Honor, some of our colleagues are saying that they can't hear through the telephone line. We just wanted to ask you if you prefer the telephone lines.
Sometimes if nobody's on the line, they may cut out. They may have to hear.
Well, there's people on the line, they couldn't hear them.
Oh, they certainly couldn't hear. It's on. Perhaps one of the longer ones can check that out. And Mr. Senna, you represent the Lee County.
Yes, sir, that's correct. Thank you for your time. Hello, my name is Jonathan Senna, and I am a Lee County Commissioner speaking on behalf of Lee County in District 4. I am the designated representative for Lee County and a member of the Eddy Lee Energy Alliance Board. Our county has a population of approximately 65,000 people, and our alliance is a long-standing consortium of the cities of Carlsbad and Hobbs and the counties of Eddy and Lee, formed under New Mexico's Local Economic Development Act, LEDA, in 2006. Additionally, Lee County is the proposed jurisdiction for the Holtec High Store Consolidated Interim Storage Facility, the CISF. Lee County has been keenly interested in the development of the Holtec site since the 2013 report from the President's Blue Ribbon Commission recommendation that a consolidated interim storage facility be established. The CISF CISF will have a real impact on our community. We expect that it will bring with it the following benefits to southeastern New Mexico. It will create 115 permanent jobs and 100 construction jobs for 10 years for our citizens. The average salary will be about $70,000. This new development will be worth $2.4 billion. It will generate significant dollars in tax revenue for schools and communities throughout Lee County. This will have an extraordinary impact on the lives of young people throughout Lee County. But we have taken steps to become familiar and even more familiar with the nuclear industry by our building on our current relationship with Urenco, a nuclear enrichment facility in Lee County. We have also worked hard to engage the Nuclear Regulatory Commission through the public meetings in our community. But we are familiar with living near a site for nuclear waste storage, as we are located less than 40 miles away from the existing waste isolation pilot plant, also known as WIP. It's a facility run by the Department of Energy, which has brought benefits to the region. Based on my personal experience as a county commissioner, as a 33-year resident, I see that our constituents and the county commissioners strongly support the Holtec CISF. One great example of many is that of Finn Smith. Finn is the president of Watson Truck and Supply in Hobbs, New Mexico. He's a strong member of our community and a business leader who understands the importance of diversifying our economy with new, safe jobs like those provided by Holtec. Another example of support is that of Steve Vierick. He's the director of the Economic Development Corporation of Lee County. He also sees the value of Holtec coming to southeastern New Mexico to provide good, high-paying jobs and to augment property taxes to help our schools. Joe Calderon is another example. He's a longtime educator and community leader who has lived in Hobbs for many years. He also sees the great value in Holtec coming to our county and bringing good, safe jobs. The last example would be Deborah Hicks. She's a business owner in Hobbs who also supports Holtec coming to our community. And we're here today to show our support. The Holtec CISF is welcome in our county, and we look forward to having Holtec provide jobs and tax revenue as well as other benefits that it will create. We're an energy-based economy. We support oil and gas, nuclear energy in Lee County and Eddy County. Thank you for your time.
Thank you, Mr. Sepp. I know tomorrow we'll hear from the city of Carlsbad. Did we have someone from the city of Hobbs who wants to speak separately?
We don't.
We don't, okay. So just tomorrow we'll make time for the city of Carlsbad. Which gets us back to the hearing petitions. And I think the next up in order would be Alliance for Environmental Strategies. Is that Ms. Simmons? Yes. Oh, absolutely. Yeah, I repeat again, if any of the speakers want water, that's why it's out there. We don't have tables for everybody here, but we're trying to be as accommodating as we can.
Welcome to New Mexico.
Good afternoon. I have, on behalf of the Alliance for
Environmental Strategies, 2 points I'd like to make this afternoon.
the first is, can't hear. My father, can't hear.
I'm having a hard time with the microphone, I think, because I'm so. Is that better?
Yes.
Okay, thank you. I'll try to look up. I was asked by AFES to address the problem of dumping of nuclear and other waste in Lee and Eddy County many months ago, because I've done some work in the area of environmental justice. I'm primarily a civil rights attorney. They specifically were interested in the particular effect on the minority population in Lee and Eddy County, which is perceived, at least, as in effect the targeting of the border area of the United States for multiple dump sites for nuclear waste and other types of waste. sort of the traditional environmental justice point that it turns out so very often that these type of sites end up in low-income minority communities in the South and on the border, and very much in New Mexico. I looked at the Holtec application as my preliminary step, and what surprised me was that there really wasn't any study that addressed in any kind of scoping process what the potential discriminatory effects may be. Instead, there was an adoption of a prior report done by ALEA, I think they call themselves, but nothing else, nothing specific as to this community right now. People were not really invited to participate in any kind of explanation of how this might affect them, and there was no real demographic study other than the adoption of what ALEA had done before. And one, for example, particular point that AFES would want to raise is what's the demographic comparison we want to do. If you compare, for example, I think this is a helpful example, if people contended that the current administration is biased against South Americans and Mexicans, and and I'm not saying that's true or false, but let's just say that's the argument, that they're biased against the people crossing the border to the south because of a problem with people from those communities, from Mexico. A demographic study that said, well, look, if you compare the people that are crossing to the people living right on that border, in the Segundo Barrio in El Paso, we're not discriminating. We treat those two groups just alike, so we don't see any discrimination. But that's really not the point, is it? The point you'd have to do is compare to the Canadian border and say, oh, well, people on the southern border are treated very differently than people on the northern border, so let's see why that is. And maybe there's an explanation. But that's what I'm saying in terms of demographics. If you compare Lee and Eddy County to the rest of New Mexico, you'll probably find similar numbers of minority population. Because Albuquerque has a big minority population. Northern New Mexico has a bigger minority population than Anglo in some counties. But that's not the comparative piece of this that needs to be done. What we're saying in our argument, and again, I know that's for a later date to try to argue this on the merits, but just in terms of standing, what I would say is that the comparative group is the rest of the country. So what's happening on the border that we think that these communities are targeted for the dumping of waste? We say that the comparative demographic is the rest of the country. Okay, that gets me back to standing. Who has standing to raise that claim? And my issue is that that was never even addressed as to what the proper demographic was. It was just an adoption. There was no consideration given to whether the minority community in Lee and Eddy County would have more difficulty with the drop in property values because of the perception in New Mexico that these areas are dumping grounds for waste, so that people aren't moving in, for example. So the property values do go down. That was a concern of one of the members of AFES. There wasn't consideration to be given to that. I think we're entitled to raise that claim as a matter of law. This application is deficient in terms of the work that was done to look at these issues. And I believe that the standing issue is traditional standing. The NRC is not supposed to have a more narrow definition of standing. If anything, it should have a broader definition of standing than is in a judicial forum. And in a judicial forum, if I'm being discriminated against by the dumping of waste in my community, I don't have to say that it came within 2 miles of me. I can say the effect on this entire community is that it's lowering the property values, lowering our sense of being a community, lowering our self-esteem, affecting our children, that they feel that they're being dumped on, that we're a waste plan, a landfill rather than a community. All of that, whether you believe me on the merits or not, because this isn't the point to determine merits, all of that, anybody in that community should be allowed to raise that instead of saying that you have to be next to the dump, because those are apples and oranges. The issue of radiological exposure goes to whether I'm going to be injured if there's an accident. Well, that's not our claim. Our claim is that there is a deficient application in terms of their environmental justice portion of their application. And if you say otherwise, respectfully, I think you end up with a situation where environmental justice just doesn't count. That's not something that has to be addressed. All you have to address is whether this is safe or not. And then you're done. If that's the rule, then it should be clear. There should be a holding that it's not a standing issue, it's on the merits. No, environmental justice is not an issue that has to be addressed in an environmental impact statement, period. All we're going to look at is whether the casts might leak or they might not leak, whether this might explode or that might explode. That's obviously critically important, but there are other people that are presenting those arguments on behalf of particular groups today. We are presenting primarily the argument about environmental justice. And so I think we have met the requirements for standing on that. Now, we would also like to participate and ask questions, obviously, about the safety of this proposal. I think we meet that because of the proximity of, well, because there are members of AFES that travel on the roads that might be exposed to the possibility of leaking casts along the highways and byways in Lee and Eddy County. So that's my second point. That's all I had to present, unless there are questions.
Thank you, Ms. Simmons. I believe Judge Arnold will begin our questions.
Your contention 1 and contention 2, correct me if I'm wrong, that basically environmental justice contentions of some sort or another?
I have two, I don't know my numbers, but the first one is as a matter of law, and I believe the second one is that we're relying on Dr. Gomez to talk about environmental racism. So yes.
Okay. I understand, how one could consider the executive order a requirement of the NRC to do environmental justice work. The commission put out a policy statement on environmental justice and say, yes, this is a part of our environmental impact statement. But I'm looking for, where is the legal requirement for an applicant to address environmental justice?
Well, I think there are several things. One, there's the Louisiana Services case that talks about that could be an issue. There is the policy statement, there's President Clinton's policy statement that has to be considered in anything that is done.
A presidential policy statement applies to federal agencies, the NRC, but an applicant is a private entity. So why does that apply to them?
I see your point. Well, if they don't present that in an application, I don't see how the NRC can rule that the NRC is complying with President Clinton's executive order if there hasn't been any evidence presented or anything in the application to address that.
Okay, so it's a matter of logic rather than being able to identify a specific rule, regulation, or law that says it.
That I know of, and I would appreciate the opportunity to supplement, because frankly that's a question that I had not considered, whether there's specifically a CFR regulation that says that the applicant specifically has to present it in their application. I think because of the natural logic of if the NRC has to consider it, somebody has to present it, and it should be part of the applicant's burden.
Okay, that's all I have on those contentions. Your third contention there is no factual support for Holtec's primary site selection criterion, which is community support. Once again, can you point to any rule that says they have to provide specific support for statements of that sort?
No, I can't, and I don't think there is in that case. My point in presenting that, and it may have become moot depending on what a Holtec has to say, but my point in presenting that is that their application in terms of the section that they did on environmental justice in their environmental impact statement was, we were invited in by local leaders, so there must not be any problem. And they did a study that basically studied their own counties as opposed to any demographic comparative study that I would see as valid. And that was sufficient. So once we're invited in by local community leaders, we're done with any environmental justice analysis. I said that's not sufficient. You need to do more, you need to do your own study, and it needs to be much more specific than what Aaliyah did. Their response was, well, this is irrelevant. It doesn't matter whether we're invited in by the local community, so you can't challenge whether we were or we weren't. And then in my reply, I said, okay, if it's irrelevant, then you have nothing in your environmental impact statement about environmental justice, because pretty much you have hung your entire hat on being invited into the community by local leaders. So that contention may go away.
Do you have any support that their statement of community support is in fact incorrect, wrong?
I don't have anything to suggest that these gentlemen were saying anything other than what they see as absolutely the truth, that their constituents, as they perceive them, support this project coming in to Lee and Eddy County. My issue is, in accordance with what Dr. Gomez said in her report, which I attached to the petition, that when you are dealing with folks that are low-income minority community, the idea that local community leaders speak for Rose Gardner, for example, isn't a definitive decision as to whether low-income and minority communities are definitely swept up into the view that I'm the local community leader and I speak for everyone. I think even, I can't speak for them, but I think they would probably concede the point that the less income you have and the more marginalized you feel, the less likely you are to come to a town hall and challenge the larger group and say, you know what, I don't want this, because I already feel like I'm being dumped on and I don't want more of it. It's not going to help me in my community as a subset of what goes on in Lee and Eddy County. So I think local leaders and local businessmen and people that have an economic interest in this fully support this, and that's their right. But they don't speak for the members of the FES or for the rest of the low-income minority population without specific evidence, and this gets back to my point of the environmental impact statement. You have to go into those communities. I can't be my own expert, and I get that, but anecdotally, I have worked in communities like this on the border for more than 30 years. And you don't just hold a meeting. When we would hold meetings, we would talk to ourselves. We wouldn't get all this just by saying, here we come, you come tell us. We had to go to where folks were and ask them, what do you need, what do you want? And that's what didn't happen here.
Thank you. I have more questions.
Thank you. Just sort of three areas of inquiry. First, the executive order, President Clinton's executive order on environmental justice. It may seem a little strange, but the Nuclear Regulatory Commission does not report to the President of the United States. And the President's executive orders do not apply. We are an independent agency. The President appoints the members, but does not supervise them, which is a little odd. We're part of the executive branch, but that is the structure. Turns out, doesn't matter, because the Commission voluntarily determined that the agency would follow the principles of the executive order. Now, as I understand the point that Judge is that an environmental impact statement is not something that is the responsibility of a private party. It's the responsibility of the government, in this case, the NRC. And what applicants must do is not comply with NEPA, because they aren't government. But what applicants must do is comply with the regulations that the NRC has promulgated to facilitate preparing an EIS. In other words, the regulations require applicants to have an environmental report, which can become the basis for much of the NRC staff's environmental impact statement. So I have a question for the staff. Do we have a microphone for the staff? And my question is Judge Arnold's question well-founded? Is there a regulation, I guess it'd be in Part 51, that requires applicants for a consolidated interim storage facility to address environmental justice in their environmental report?
I'm Sarah Kirkwood for the NRC staff. We said it
And
is.
just for the record, that's Ms. Silva. Ms. Silva. Kirkwood.
Sorry, Sarah.
Kirkwood.
Sarah Kirkwood. Silwood.
Sorry, so
for the NRC staff. I'm not sure that there'd be a specific requirement in Part 51, but the NRC staff guidance, which is cited in our answer.
Stand up.
Stand up.
Newer 1748, Appendix C lays out the categories of information that we expect to see in an environmental report's environmental justice analysis. And I would say that anything that the staff is expected to have in an EIS for purpose of contention and disability should be in the ER.
But that is a new reg, correct? That's not, that is guidance, that is not a regulation of the NRC.
That is true.
Could I ask one? Let me quote a sentence out of the introduction to that document. Applicants and licensees are encouraged, but not required, to use Chapter 6 when preparing environmental reports for submissions to the NRC. Does that make it sound like a requirement?
Following our guidance is not a requirement. So we would not deny an application for lack of complying with that document. However, for purpose of contention and disability, if it's something that we think needs to be in the EIS, I would posit that it would be potentially an admissible contention. I don't think that's the standard.
Potentially admissible or inadmissible?
Admissible.
Could I respectfully ask a question?
Yes.
Maybe of Mr. Arnold, and Mr. Ryerson as well. If the NRC is then required to consider environmental justice in an environmental impact statement, how does the NRC go about doing that if it doesn't require the applicant to do it? So for example, if I'm denied because, oh, it doesn't have to be in the application, that's the current hypothetical or possible position, whatever, and then you're supposed to decide, respectfully again, whether this is going to affect the environment in a way that it should be denied. Do you have to do the work to go out there, or do you deny the application because it's not clear what the environmental impact would be? I mean, it seems there's a bit of, with all due respect, and Mr. Ryerson will remember this from law school days, angels dancing on the head of a pin, to my mind, because if it's required that there be an environmental impact statement that includes environmental justice, and the NRC guidance provides that that should address environmental justice, you are correct, Mr. Arnold, that may isn't shall, but I don't see any way around it.
Mr. Silver, yes. Do you want to make?
The ultimate obligation is on the NRC staff in this case If applicants did not include the information, we did include the information, we did file hearings. But if we had not included the information, the ultimate obligation to prepare environmental impact statement rests with the NRC staff. They would go out and develop the information. They would include that information in the environmental impact statement, which is required by their regulations. And the fact that they chose voluntarily to follow the executive order.
Okay, I think we're clear on the point that, in fact, whoops. You okay?
Yes, I was listening too hard to the vice president. Apologies.
Here's where I think we are. There's no question. You may say it's inadequate, but the applicant believes that it did submit environmental justice information as part of its environmental report. The staff says that if they didn't, because of the new reg, not a regulation, but because of the staff guidance, they would have agreed that a proper challenge would have been admissible. So the question is, I think, whether your challenge is to what they've submitted is adequate. So I think Judge Arnold has raised a very interesting point that there's not a regulation that requires it. In fact, they get past that to where we started, which was the adequacy of what they've submitted, of what the applicant has submitted. Let me move on. I have two other areas. Ms. Simmons, you are absolutely correct that in the federal courts, standing has a constitutional dimension. There is a case of controversy requirement in the Constitution for the federal courts that does not apply to the NRC. Nonetheless, once again, the Commission has declared a policy that it would generally follow current standards of standing that is applied in the federal courts as a matter of the Commission's discretion as an agency. And they've indicated, and this is all in your pleading, I'm saying more than I need to, but they've indicated there's different ways to satisfy that. For power reactors, there's kind of an arbitrary judgment that anybody who lives within 50 miles has standing. For groups, if they can show that a member has standing independently, either traditionally or through a presumption, and the interests of the group are aligned with what's at stake, there's such a thing as representative standing. So that's what we're really talking about here. And this board tends to be guided somewhat by what the Commission does. The Commission has found, I believe, standing, so the Commission or other boards have found standing in the case of interim storage facilities at a distance of 17 miles, I believe. Your closest member is 37 miles, is that correct?
That's correct.
Okay, and I think if you take the District of Columbia Circuit in the NEI case, which dealt with Yucca Mountain, I think found 18 miles to be sufficient, tad more distant than the Commission has. But given that these cases are 17 or 18 miles, and your closest resident is at 37 miles, are there any cases that we are missing that show the Commission accepting, or another board, accepting a standing based upon proximity that is closer to your 37 miles?
That I know of,
yes.
Mr. Ryerson, no, but let me also take exception to the premise that the shorthand, the handy shorthand, admittedly so, that there's a certain proximity you get standing, a certain proximity you don't. If your problem is with the radiological exposure, is not the point that's being made here. So that there are cases that say that if I am denied a procedural right, which I would assert that a person who is a minority, member of a minority, living in the community that is within, there's a point at which the rubber band breaks. If I'm in New Jersey, I can't complain about the discriminatory impact of what happens in Hobbs. But if I live in the community of Hobbs, if I live in the community of Lee County, and the cumulative impact of dumping on the border communities is hurting me, and I think that that would come out in an environmental impact statement that is well done with an environmental justice aspect. We've gone through whether that's the applicant's responsibility de facto or whether it's not. But I think I have standing to challenge that issue as not being sufficiently addressed in the application, whether I'm close to the radiological exposure or not, because that's apples and oranges. That's not the point I'm trying to make. So to me, it's like saying that if I am, Hatch, New Mexico has sundown laws, used to, before legal aid got involved, where if you were a Mexican in downtown Hatch, you were in trouble. They passed a law saying you can't have a double wide trailer and live in a double wide trailer in Hatch, and at the city commission said, this will get rid of those rats, meaning the Mexicans. Now, if I don't have a double wide trailer and I don't go downtown in Hatch, I'm not close to either of those, but I'll tell you, if I'm a Mexican American, I can challenge that because I'm not specifically challenging the fact that I can't have a double wide. I'm challenging that you can't pass laws targeting me as a Mexican American, and okay, we're off to the races to make my argument on the merits, but I definitely have standing to make that challenge. Now, I take your point, Mr. Ryerson, that that's from judicial cases, but there are also NRC cases saying that, for example, a deficient environmental impact statement is a basis for standing by the group that's challenging the insufficiency of the environmental impact statement per se. So I think it's interpreted broader than you are suggesting because of the nature of the claim we're making. Second, and this is more of the traditional approach before the NRC, my clients do travel on these roads, and there is an admission in the application that some of these casts may leak and they'll be just sent right back if they're leaking, and that's not enough assurance for my clients. So they have standing on that basis. And let's see, one of my, here, I'm going to read this note. One of my AFES clients, Lorraine Villegas, drives for work within 1/2 mile of the site multiple times daily. That's effective. That's in the affidavit, so I would add that. But again, I don't think that's the be-all, end-all. I think we have enough because of proximity. The traditional analysis NRC applies because the folks travel on these roads and also travel close to the site itself, based on the very traditional analysis NRC applies. But I also think that it's way too constricted to say that if you are alleging that you have been discriminated against by the multiple instances of dumping on the border, just very traditional definition of a violation of environmental justice principles, if that's my contention and I live in that community, that's sufficient for standing.
All right, I think we understand your position on it. I have just, I think, one more question, at least at this point. We've talked, I think, mostly about your contentions 1 and 2. Contention 3, if I understand it, seems to require us to find that community support would be a relevant issue under the National Environmental Policy Act. And am I correct that that's what you're saying?
That's what I just responded to from the question from Judge Arnold, which is that the environmental impact statement that Holtec submitted when it was addressing environmental justice focused on the support of local leaders. And to my mind, that means that raises the question whether there is truly support in the community for this, as in if everybody's happy that this is coming, then how is that discriminatory? And that was their position, to my mind, in their application. That was their environmental justice rallying cry. So my response was, well, but that group that purports to represent the entire community wasn't open to all. Now, if they're withdrawing that, which in their response they appear to be saying that community support is not a relevant consideration. That's not what we hang our hats on. If that's so, then my response to the environmental impact statement is moot, because they're withdrawing even that support and saying, okay, we're just going to rely on the study that Aaliyah did, not on the fact that Aaliyah is all for us. I do find it, I must say, respectfully to the gentleman, respectfully to the NRC, I find it very ironic that they're allowed to stand up and say how great this is going to be, when it doesn't sound to me like they meet the proximity test, but yet their views are interesting. My clients are members of this community that feel excluded from the process because of their position as minority low-income folks, and yet maybe they're going to be denied standing. I think they have the same sort of interest as the local community leaders do in speaking to this issue, because man, we're the folks, we're the New Mexicans. They're the New Mexicans, so I get why they get to speak. So we're the New Mexicans too.
Thank you. Judge Burroughs, did you have a question? No.
Thank you for your time.
No more questions. Okay, thank you. All right.
Mr. Chairman, would it be possible to exercise your discretion under 10 CFR 2.315 to allow some portion of time for the community to orally at least address some of these issues?
I don't want to seem curt, but no. We are not permitted to take evidence in those types of statements. Some boards do that, usually closer to an evidentiary hearing. It's very rare to ever do that at the time of contention and admissibility, which is a legal issue concerning the adequacy of these particular pleadings. So we have petitions that have been filed by the local governments. They are unopposed. As a courtesy, we are allowing them an opportunity to speak. But the general public, this is not an opportunity. There conceivably would be another opportunity. I'll tell you personally, I'm not a big fan of those because I think they mislead the public, because we can't take what people say as evidence if we're close to a hearing. We can't respond to what they say. And frankly, often the issues at that point are very different from what's on the minds of most members of the public. So in any event, at this point, unfortunately, we will not be doing that. But thank you for checking with us. I believe Mr. Lodge? Yes. And you are representing?
The Rainmaker, Your Honor.
Representing the joint petitioners. The Rainmaker, all center.
Before I get started, I'd like to indicate to the panel that it is possible, depending on the questions that I'm asked, I may be consulting my kitchen cabinet. Several of my clients are client affiliates, and I respectfully request the board's indulgence. I understand the complexities. I understand enough that this is a complex proceeding.
As long as you are speaking to us and not your clients,
correct,
that's fine. Thank you.
That's why they call us mouthpieces. Thank you. May it please the licensing panel and counsel, I'm here on behalf of the, what I informally consider to be the transportation interveners and public citizen, for the precise reason that this is a national policy determination. It's the implementation of a national policy that hasn't actually been fully hammered out or discussed in a meaningful way for quite a long time, but that there are gaping problems with the Holtec application as it has been given to the NRC. In our view, some of the gaping problems are that there is literally no addressing within the context of the application of the fact that there may not be a mere 10,000 shipments at 500 per year for 20 years, but there may be as many as 30, 50,000, possibly even 80,000 shipments of smaller uniform canisters. From the reactor sites, that particular situation stems from a 2008 DOE policy pronouncement relative to the Yucca Mountain Repository. The policy pronouncement essentially is that wherever the repository may be, that ultimately it will be in the interest of the management of the waste and the public health and safety for there to be a uniform standard applied to the canisters that are put forever in the ground for storage. That hasn't been addressed here at all in the application papers that I've read. It implies another aspect that has not been adequately addressed, but which is sort of covered in the application papers. That is the presence or non-presence during the operating life of the Holtec facility of a dry storage system or something akin to it. And by that I'm talking about a complicated technological system that protects the workers and minimizes radiation leakage or exposure, that allows the unloading of canisters for the purposes, among other things, of either remediating arriving canisters that are damaged, remediating canisters on site that, as time passes, become damaged or show signs of contamination, or transferring spent nuclear fuel delivered to the site from transport canisters that are not of that smaller uniform size contemplated by the DOE policy. Another problem, which we believe is very distinctly related to these transportation issues I've been talking about, is that we're talking about millions of miles, millions of road miles, millions of water miles, and millions of highway miles of travel for the thousands of loads of spent nuclear fuel we're talking about. And I might point out perhaps one of the most striking omissions from the application papers is this complete lack of discussion, lack of specificity about the probable transportation routes. We'll get into it, I'm sure, with the board's questioning, but essentially the Holtec position appears to be all that's way off in the future, and we haven't made those decisions and nobody can figure it out yet, it's just not knowable. And we think it's quite knowable, that it's quite imputable, because we've been here before. In the Yucca Mountain Environmental Impact Statement documents, there's considerable discussion of the national rail system. There's considerable discussion of the barge hauling, which is quite significant and almost invisible in any national perspective on this problem, and the highway travel that will be necessitated. So we're talking about an entire huge, what they call in my law school Latin, a sine qua non, without which the project is nothing. Without transportation, there won't be a Holtec. And transportation is a big issue because 218 million people live within approximately 80 kilometers, 50 miles, of the transportation arteries that we, to a pretty high degree of certainty, are certain will be used. Approximately, according to the application, I'm thinking somewhere in excess of 94 or 95% of the actual final delivery leg to Holtec will be by rail. Some of the early stages, however, which are kind of remarkable to me, will be barge-borne canisters of waste on the Great Lakes, on Delaware Bay, along the Florida Atlantic coastline, around Cape Cod, Boston's Bay, down through the river system, the Missouri, Mississippi, Tennessee rivers would all see barge hauling of this material. And as I say, we know this because we have an imperfect but somewhat analog, I should say, already in existence. That being the work that was done, much of it through the state of Nevada and by the state of Nevada, on the transportation implications for Yucca Mountain. One of the things that is a grave distinction, however, is that Yucca Mountain, were it to become the repository, would only dispose of 70,000 tons, less than half of the contemplated storage in shallow surface burial in the desert of southeastern New Mexico. So this is a major national issue. The grassroots organizations and public citizen are here, in effect, as symbolic plaintiffs, if you will. They are interveners on behalf of the huge amount of the country's population that is potentially affected. One last point, and then we can certainly turn toward the issues, is that the 2002, where is it? Pardon me one moment, where I try to decipher my left-handed scroll. The 2002 Final Environmental Impact Statement for Yucca Mountain basically set forth a region of influence, and I've mentioned this in our pleadings, a region of influence out to the 80-kilometer, 50-mile radius, also stating that the area of immediate environmental effect could be 800 meters on either side of a right-of-way, whether it be rail or road, highway. And this was for purposes of assessing the transportation impacts in the Yucca EIS side of the proceeding. We believe that that's logical. It makes sense, and in fact, the Department of Energy, the name of which keeps recurring in these proceedings, might, if asked, strongly advise that the NRC consider it as a region of effect. With that, I'm ready to take your questions. Thank you.
Thank you. Judge DeCouros, did you want to begin?
Yeah, since we started the transportation, let me ask a transportation question. Contention 11, your contention 11?
Yes.
You say that you're referring to the shipments that you're now talking about, that they'll be subject to, if not vulnerable, to human-induced event risks over the lifespan of the transport campaign.
Correct.
And you say it is necessary to define, understand, and communicate design-basis events so that communities along the transportation routes and at the initiation and destination points are risk-informed. Now, these design-basis events that you're talking about, let's see. How do you relate those to the requirements of Part 71? And I think subpart F of Part 71. But how do you relate to what design basis events are you talking about? Are these something that has yet to be created and you're seeking that they be created? It's not clear.
Well, it's a little difficult to predict design basis events until you have designed transport casks and canisters. The problem presently is that it's our understanding that none of the existing storage casks and canisters on site at reactors will be ultimately the transport units used to haul material to New Mexico. So first of all, there's that problem, which is rather serious. How does the possibility of sabotage or terrorist events relate to this project? Is that I'm not sure I understood your question, sir.
You're saying that there should be a set of design basis events defined that would risk inform the public along transportation routes of vulnerabilities associated with potentially terrorist events.
Right.
And what I'm asking is, what is the nature of these design basis events, and how are they different from the Part 71 requirements for transportation, for canisters of transportation tests?
Well, the nature of the design basis events is if there is a successful use deployment of a tow missile at an in-transit cask, there could be a major environmental and public health event. And you thus have apparently not been able to successfully make a delivery that conforms with Part 71. I still am not certain I understand what you're asking for here.
Are you suggesting that Part 71 requirements are inadequate?
I'm suggesting that compliance with the Part 71 requirements encompasses a lot more than the applicant is suggesting. In fact, one of the problems that we have identified is that 71 talks about ISFSI facilities, and I think the conventional understanding of an ISFSI is not the Holtec waste facility. A standard ISFSI is maybe a few hundred or a few thousand tons stored at a reactor site, or maybe a combined storage event at a reactor site. It is not 173,000 metric tons having traveled millions of miles to be congregated. And I think that a realistic reading of Part 71 and applying it to this project is going to definitely imply a much more expansive sweep of the implications and the necessary steps. One of the problems here, and it certainly has been discussed well beyond the threshold, is the legal problem of whether the facility is even lawful. And along with that, there is a paucity, because of the way the NWPA is written, there are not adequate regulations that envision this type of facility. There is discussion in the NWPA of a CISF, Consolidated Interim Storage Facility, but it's tiny in comparison to this. It's minuscule. And of course, it's not even within legal reach at this point. So the point is, yes, Part 71 is there, and yes, it must be obeyed. And no, I'm not suggesting that we challenge the rule, but I think that the rule must be read in the most expansive possible way.
A quick question on the Part 71 transportation.
Yes.
Does that have an automatic opportunity for hearing in it? For a hearing like this?
This is, I would say probably not.
So as far as you know, it's either you're heard now on transportation or you're not heard at all?
I'm not sure I agree with that notion. This is not a substantive hearing. It is merely a procedural one.
Right.
And I don't recall, to answer your question, number one, I want to correct myself. Part 72 is what governs dry gas storage regulations. Part 71 is the transportation regs, of course. But I think that transportation is the essential element without which the project is it's a non-starter, it's an impossibility, even if you assume that the legal hurdles have been successfully crossed. So we believe that transportation, by unspoken implication, has been segmented out of the project scope.
It sounds to me as if you're saying that there should be separate analysis that is, so to speak, a risk study on transportation. And that as a result of that, there should be defined series of events which are not currently incorporated into the current regulations, Part 71, and that should form the basis for what? You say risk informing the people along transportation routes. I'm not sure, I don't know what that means exactly. So to what end would all this be taking us?
Number one, it wouldn't be necessarily a separate study. It would be part of the draft environmental impact statement. Number two, of course, as the panel is well aware, part of the purpose behind an EIS is to inform the public, but also to signal to the public that the agency itself has both consulted other agencies and taken into account the maximum number of reasonable scenarios, reasonable problems, and environmental impacts that might befall were the project to go forward. So we believe that it's a very reasonable request, and NEPA trumps Part 71 to the extent that NEPA is not in conflict with Part 71. And we believe that the nature of this unprecedented project is something that demands a much fuller transportation analysis than has been done, and has largely not been done. I just want to point out the data that we've been relying on to identify probable transportation, mainline rail routes, mainline highway and water routes, is taken from an entirely different project's EIS. That's how low the level of information is within this document. And it will involve a lot more waste and a lot more travel. And let me tell you why it will involve more travel. It will involve more travel because this is an interim site. So the material goes to New Mexico and then supposedly would go ultimately to a repository in another location. And the way Holtec has proposed to manage this waste, they actually reserve the right that a non-conforming shipment delivered to the site can be returned to the originating reactor site, or now, in the last week and a half, we've learned that they're proposing it might also be diverted back to a site that can remediate a damaged or leaking or contaminated canister.
Okay, thank you.
Thank you.
Let me move on to contentions 5 and 12. And my concern here, well, let me just say that I can read contention 5 to be human activity that may cause some geologic effect on the plant, on the facility.
Yes.
I can read the other contention, 12, to be naturally occurring geologic conditions.
Right.
Okay, so I'm reading those correctly.
Yes.
So first ask the question, is subsidence of the land something that you believe would damage this facility?
Yes. I'm not a geologist, but I suspect that in the Permian Basin, there has been a study, a juried study within the last year and a half or so, that has pronounced that in the last 3 decades, more or less, there's been, in some places, as much as a 40-inch change in elevation. And yes, subsidence, that's enormous. You don't have to be a geologist to know that that's incredible. So yes, and the Permian Basin is either at or fast approaching the status of the most prolific productive oil and gas patch, certainly in the Western Hemisphere, if not the globe. So, and it's not showing any signs of slowing down in the coming decades. So there are going to be new geological problems, including seismic events, that we believe have to be taken into account.
It's your position then that the environmental report and perhaps the SAR did not adequately account for these geologic conditions that you're worried about?
That is correct. And I might add that from what I understand, the Holtec location is within this, I'm thinking it's about 20,000 square mile Permian Basin area. The Holtec location is near the most productive zones. And there is presently cracking going on 2 or 3 sides. And a major potash mining facility, I don't know if it's presently operating, but certainly there's been geological disturbance from a potash mining facility hard by the site.
In your contention 12 pleading, you reference a report from your consultant, and that report provides a sort of different geologic picture than the environmental report in some respects.
Yes.
Just a cursory look at differences between them. I could see that section 2 of your report talks about the nature of the valley there. And it ends by saying the Holtec site appears to be sited on top of a karst valley. An extension of well-studied nearby karst valley that has undergone subsidence. Section 3.3 of the environmental report says, comparison of conditions at the site with those conditions favorable to karst development indicates that conditions at the site are not conducive to karst development. You couldn't be any different than that. One says very much karst valley, the other says none. But yet in your pleading you didn't point to the application. You didn't connect your consultant's report to the application. It isn't my job to find such discrepancies. It is your job to find such discrepancies and report them as in the contention. How would you answer that?
I think you've summed it up correctly. I believe, however, that the distinction that Your Honor just noted reflects an issue of fact, and we aren't even required and compelled to meet a prima facie standard of evidence and proof for purposes of admitting a contention. I think it is the distinction, the difference in factual position is sufficient to warrant admissibility of the contention and further investigation.
So you're telling me that you don't think you really need to tell us what's wrong with the application, that just the fact that that information is out there to be found is sufficient? Is that what I'm hearing you say?
No, sir, I'm not making that brazen of an assertion. I am saying that the obviousness of the factual controversy is such that there should be contention.
Your contention 5, rather simply worded, horizontal hydraulic fracturing, parenthesis fracking, is certain to occur underneath the site. From what I can see, that's not in dispute. What is in dispute is that the fracking will occur at depths in excess of 5,000 feet.
Yes.
And statements are made that at that depth, there's absolute assurance, in essence, that there won't be an effect on the facility.
That, if you're referring to statements that we made in our petition, that's not inaccurate.
These are, when I looked at your petition, I also looked at the answers from Holtec and the NRC staff.
Just wanted to clarify that.
Yeah. Clearly that wasn't something you said.
And as we were just discussing a few minutes ago, there is scientifically documented subsidence going on. So yes, there is certainly some distinct likelihood that there will be geological effects noticeable at or near the surface. The problem here is this facility has to be run perfectly. It effectively, the radioactive waste and the radiation must be contained as perfectly as possible for a very long time. And the stability of these canisters for 100 or 120 years is going to be an ongoing experiment. We've never done this before. So we believe that the balance of equities certainly calls for there to be more, not less, investigation via contentions.
To your knowledge, is there any level of subsidence that could be tolerated by this facility?
I'm not a geologist and I don't consider myself qualified to say, but I would suggest that we're talking about subterranean platforms of human installed and dense material that are going to be rigid and not very flexible and may be cracked or otherwise fissured, both by the unforeseen problems with the weight from above as well as from shifts from below. It just seems to me, from a lawyer with a poli-sci degree, that what we're looking at is geology that has not been tested nor fully explored nor explained in the context of not just active oil drilling, but the most intrusive form of extracting gas and oil, which includes underground explosions to create caverns into which to inject under high pressure industrial chemicals to draw out the oil and gas. We don't know what that's going to mean over the next 30, 50, 100 years. We don't know what geological changes will be induced. Very little of our geological understanding of the Earth's crust is gleaned apart from oil and gas development.
The statements are made in your contention that the activities that are taking place in the surrounding area of the Holtec site are similar to what types of activities would take place at the Holtec site, including fracking below 5,000 feet.
Correct.
And you also state that the surrounding area has exhibited signs of subsidence.
Correct.
Therefore,
not necessarily the immediately surrounding area. I don't believe the analysis that was published a year or so ago was that close to Holtec, but it's in the Permian Basin.
also, environmental report, I think it's page 344 of 482, is on a PDF relative basis. Says the SAR at I think it's page 254, 2-54, indicates that there are no surface, drill hole, or mining indications that subsidence and collapse chimneys occur at the site. Basically, it's saying subsidence is not a safety concern.
No, and the facility may not even be operable for some years to come, during which time there will be incrementally more hydrofracturing activity in and around the site, and maybe even underneath it. You know, as I was writing that contention, I was thinking to myself, what would it have sounded like in the Yucca proceeding a few years ago if oil and gas companies were clearly and rather nakedly announcing, sure, we're going to frack right around Yucca Mountain. What's the problem? I think it would have been an enormous problem, not just scientifically, but from an image, optical standpoint.
So your consultant believes that subsidence is a concern at the Holtec?
Absolutely, yes, sir. And seismicity, I think, is a concern that is increasingly becoming attached to the presence in the area of fracking.
I think we'll take a break shortly. Just one or two questions that I have at this point. Following up on Judge Koukouros' comments about grappling with the application. I mean, the commission has said, and I think I have this as almost a quote, the staff will correct me if I'm wrong. The commission has said that petitioners have an ironclad obligation to read the application and to identify genuine disputes with the application. And, I mean, do you disagree? I mean, we should follow what the commission says. Don't you agree?
I'm aware, certainly, of the commission's pronouncements. I think, however, and this is not necessarily to differ with them, I think the obligation has been met with the evidentiary presentation we've made. I think that there is a tendency to overinterpret what the commission actually seeks, because, as I say, a prima facie standard isn't even applicable to the evidence here. We're demonstrating some controversy, in fact, and that should be legally sufficient to go forward with contention being admitted. And I've been litigating NRC cases for a long time and have certainly learned a lot about draftsmanship. But I do believe that we've met the standard to present information that a reasonable examiner of the pleadings would find that there is sufficient evidence of a controversy to go beyond this stage.
Thank you. I have just one more observation, really not a question, but more of an observation. And I think I understand that there are contentions that challenge how long these, quote, interim facilities might be in operation. But we should not forget, and I urge all petitioners as you make your arguments to remember this, that the Yucca Mountain facility was subject, remains subject if it comes back, to a set of regulations that contemplate standards that will be met for the period of geologic stability. The period of geologic stability of the Yucca Mountain regulations is defined as 1 million years. That is longer than 40 years, it's longer than 100 years, it's longer than 120 years. And so I think as you make your arguments, be a little careful about drawing too direct analogies to Yucca Mountain. They are very different proceedings, I think, in the boards. But let's move on. I think if we take a break now until, say, 3 o'clock, we need to finish at 4:30, so we can take one break till 3, and we just two announcements. We have, with the NRC, has reserved and paid for this space for 2 days. So apparently, if you have heavy binders or anything and you want to leave them, there will not be a cleaning crew coming in. You may do that. I wouldn't do it myself, frankly, but it's an option. There were some questions about timing. I think we said we will start tomorrow at 9, and we were asked when we would finish, and that kind of depends on how long the questions go tomorrow. So my best guess is that we will finish we will finish before 4:30 tomorrow. Whether we just have a morning session or not, I just don't know.
More intrusive question, Your Honor, is what's on the
Plaintiffs, oh. You know, the number of people who was on the flight that at least who was on it, we were on it. That's right, we should take a break tomorrow at 10 o'clock so that people can sign in to their All right. We might do that, actually.
Maybe we could just have a scanner installed in your lobby from here.
All right, we are back to examining Mr. Lodge.
Your Honor, before we proceed with further questions, I have a couple of things I would like to respond to. One of them is to supplement my response to Judge Koukouris. In March 2018, the NRC staff sent their first request for additional information, RAIs, to Holtec. And RAI 2-2, specifically, I haven't seen the responses, but the staff requested assessments using site-measured geotechnical properties to demonstrate that the soils at the subgrade and undergrade of the storage pads and the canister transfer facility would be able to withstand the loading assumed in the certification of the high storm UMAX canister storage system. It goes on to describe expressly what data they're looking for, but clearly the staff is concerned that the analyses should, quote, demonstrate that the subgrade and undergrade soil properties at the high store CIS site are uniformly better than those assumed for the general certification of the high storm UMAX system. So the staff is indeed also concerned that there not be human-induced geological change just from the fact of the great weight that will be brought into the area of having this facility. And Judge Ryerson, in response to the comments you made just before the break, I believe that Your Honor was referring to the post-closure requirements of Yucca, which indeed do require, impose certain standards out to 1 million years. But there is some analogous pre-closure application information that had been submitted by DOE governing the approximate 50-year period of actual operations of the Yucca facility. And those particular requirements have been conformed to Part 50, which is fairly analogous to Part 72 requirements. So the Yucca operations, which incidentally have, as things were left at the last cliffhanging episode a few years ago, the Yucca requirements are that there will not be any loading, unloading of canisters at the Yucca site. All of that has been moved upstream, if you will, into CISFs and/or reactor sites. Thank you.
Thank you. I think now Judge Arnold has a number of questions for you.
Your petition, this question will be familiar, lists the 10 CFR 2.309F criteria for admissible contention, including item 3 that it be within scope and item 4 that it be material to the findings the NRC must make. Most of your contentions did not address either of those. So would you tell me, do you think your contentions are in scope and material?
Yes, we do believe that.
Also, you make numerous references to the Nuclear Waste Policy Act. What evidence do you have that that is relevant to this licensing procedure?
It's a good question. It certainly should be. And we believe that it is being violated in not being observed properly by the license, no pun intended, the poetic license that's been granted to Holtec to pretend that there actually would be two financing streams instead of utter dependence on DOE for cash and liability protection.
Concerning contention 1, as I understand it, you're not objecting to the fact that you don't have access to the redacted pages, but rather you are claiming that the redaction itself is a violation of the National Historic Preservation Act. Is that correct?
Insofar, yes, it's correct, but it is also violative of NEPA because it is another review that has to be addressed or mentioned and disclosed in some respects in NEPA. So yes.
In their answer to your petition, staff cited the Section 304 of the National Historic Preservation Act as their authority to redact the information. And in your reply, you seem to go further into depth as to the process of obtaining access to Sunset being unreasonable. Are you changing the focus of your contention, or do you think this is still under the same contention as originally?
That was simply a rebuttal argument that we were making. And in fact, I was looking in the last few days at the latest revision of the environmental report, which still contains enormous redactions. The thing that jumps out is that literally 1/4 of the pages of the ER have been redacted for this apparent cultural properties purpose. And if we're talking about this being the foundational document from which the DEIS ultimately may be formed, you're talking about depriving the public of access to what cultural resources are threatened or actually going to, if the project goes forward, be destroyed. And the public has, under the NHPA and thus indirectly under the NEPA, has mitigation, comment, and input opportunity, which is being denied. And at a minimum, we have a contention of omission. I might add, there have been, I think I've seen RAI or other correspondence between the NRC staff and possibly the State Historic Preservation Office of New Mexico, only dated in September, so that there's finally some movement on the NHPA aspects of this. But again, that letter, as I recall, even continues in effect the redaction and confidentiality.
Concerning contention 2, having to do with reasonable assurance that it can obtain the necessary funds, on page, in your consolidated reply to Holtec and NRC staff on page 25, you state, Holtec has presented essentially 2 applications to the NRC. One postulates a legal pathway to financing and commissioning, but is economically improbable, and the other one lays out a legally impossible pathway. Let's say that you're correct, and that one pathway is illegal. If the license is granted, and the DOE can't get title to the license, then what happens then? Would they be able to run a consolidated facility just for the utilities, or are you saying somehow that license still wouldn't be valid?
Well, license validity, with respect, is not so much the issue as financial reality. And it's my understanding that the Price-Anderson Act will not attach to a private facility. And that means that 10, 30, 50, 80,000 shipments of spent nuclear fuel done as a supposed private enterprise project will all be uncovered, unless, of course, there's some brave underwriter out there in the global economy willing to cover the possibilities of a serious nuclear waste accident. The problem here is that it's not just improbable. We think that in practical terms, the private sector stream of financing is impossible, and that it is only used as a means of camouflaging the DOE thing. I'm troubled by the fact that one of my law school, the things drummed into my head was that courts do not exist to give advisory opinions on theoretical questions. And administrative agencies, you are the trial court, you are the quasi-judicial body, you're the trial judges, as you well know. And effectively, this is a request for a theoretical what-if opinion. And we believe that just following that simple principle, this board and the commission itself cannot possibly entertain this application. Thank you.
Contention 3. The environmental report is incorrect in that it contains a gross underestimation of the volume of low-level radioactive waste that will be generated by the use of concrete and other materials for bunkering the spent nuclear fuel canisters. Now, I looked through the ER and I could not find any estimate of the volume of low-level waste. Could you cite to where that is? All I could find was small.
I believe it's in the GIS. I think that's what the applicant is assuming would be generated.
Okay. And you don't know what the value was of that?
It's in the Holtec answer. It's a tiny fraction of 8 million tons, I can tell you that. I think it's something on the order possibly of fewer than 200,000 tons. And incidentally, Your Honor, again, this raises the specter of that 800-pound gorilla, which is that depending on where the loading of the TAD, transport and disposal canisters occurs, whether it happens at the reactor sites or if it happens at Holtec, there could be a very significant change in the volume of low-level radioactive waste generated as a result of the Holtec project.
Do you have any factual support for your assertion that concrete would become radioactive?
Other than common sense in the fact that even in its answer, Holtec basically quibbles with our number, but not with the phenomenon that irradiation can and will occur in the immediate vicinity. If these canisters are emitting seriously public health threatening measurable radiation at 6 feet when they're being transported, they certainly are going to continue to emit neutron and other radiation for a long time in place, in situ.
Now, I inferred from what you said that you also believe that if it does become radioactive, that it can't be decontaminated. Do you have any support for that?
No, and we weren't making the argument that it is impossible to decontaminate it. We were making the argument that the initial quantification is tremendously off base.
On page 41 to 43 of your petition, you discuss the cost of repackaging spent fuel for disposal, citing the Alvarez report as support. How would the overall cost in waste disposal differ between having this central facility and having it at individual IFACs? I mean, wouldn't the same repackaging be needed?
The answer to that question is yes. And the assumptions, of course, in the Alvarez report were that, I think that was the cloning station, but that if it were done there, here's what we estimate. And Alvarez's point is that I think the ultimate, if we're talking about DOE taking title, the taxpayers are not being having it fairly explained and disclosed to them what the real costs of just having this interim storage way station for 100 years will really be. That act is going to have to happen somewhere, the recombination, if you will, of the waste into different canisters. And as presently explained to us, the Holtec proposal is they will take all canisters, they'll take all comers, regardless of brand, which I think NAC is here to dispute, but that none of those will be appropriate for use in a geological repository. So there's going to be an enormous expense point that is not disclosed, not quantified, not discussed.
And since Yucca Mountain or any other repository doesn't seem to be right on the horizon right now, I would not expect this repackaging for disposal to occur within the current licensing period. That being the case, why should it be discussed in this application?
With respect, you're assuming that it may not happen in this licensing period. The fact is it's going to have to happen. And the additional fact is that you do raise the interesting problem that Holtec itself has said that an appropriate, robust CISF needs to be able to operate effectively for 300 years, not 100 years. This is an important compact with the state of New Mexico that the material will move after a certain specified period of time. And we think that probably serious gestures technologically preparing the waste to be moved to an ultimate repository is going to be a necessary matter. And regardless of the time frame that Your Honor suggests, the scope of this project is 120 years. And it is incumbent upon the NRC to consider the environmental impacts, which includes economic effects, out to at least that period of time. And just as we're told that we need to change our expectations of the CISF, one of those expectations is it will be time limited, and it will only be a way station which prepares or at least ensures uniformity of the waste to be moved to its ultimate destination.
Okay. On to contention 4. Severe accident mitigation during transportation to and from the Holtec CISF and at the CISF. And spent nuclear fuel in greater than Class C storage and management operations at the site may not be treated as generic issues and excused from consideration within the EIS. Now, on page 47 of your petition, you argue that the Holtec waste storage facility cannot be covered by the continued storage GEIS because the GEIS assumes the facility will have a dry transfer system. But you go on to state, continued storage GEIS finds there is no dry transfer system capability anywhere within the United States. And that suggests that the logic says the GEIS applies to no current ISFAC. Would you agree with that?
Yes.
Okay. On page 48 of your petition, you argue that the generic EIS is not applicable because the Holtec facility is much larger than the hypothetical storage facility, or the one used in GIS. Would this particular objection go away if the Holtec facility was for 40,000 metric tons, the same as assumed in the GEIS?
Well, first of all, it isn't.
Right.
We're talking about something that's nearly 4.5 times the size. But secondly, the problem is even with the 40,000 ton facility, you would be looking at some commitment at some point within that first century to having a DTS present. Our logic, if that's the right word, behind this is when you have such an enormously larger volume, larger number of arriving cargoes, the odds increase that there will be a need for a DTS. And incredibly enough, in the last week and a half, second round RAI responses that have appeared in Adams indicate that Holtec itself now believes that their return to sender system has to contemplate having the presence somewhere, not on the Holtec site, of a DTS system. In an RAI response, they actually say that if they find non-conforming casks that are leaking or are contaminated externally, what have you, that they will be held on a siding and ultimately returned to the originating reactor site or diverted to a site with loading capability. So now Holtec is sort of starting to faintly mimic the theme that, gee, somebody's going to have to be able to fix these.
Now, the current license application is for a facility holding only 5,000 metric tons, not the whole 100,000 metric tons. So, does this specific objection that it doesn't match the size assumed for the GEIS still hold for this licensing action where they're only looking for 5,000 metric tons?
Yes. Yes, it does, and we believe that the 20 different licenses of 5,000 each is probably calculated to get around some type of statutory difficulty. Again, the entire project is what must be considered at this early phase of the planning and licensing, and that's what NEPA's there for. If I may, I'd just like to have one moment.
Sure.
Thank you. Let's proceed.
Okay. Next question. On page 49 of the petition, you state, quote, the Holtec CISF does not qualify under NRC regulations as an ISFC. Now, I took a look at 10 CFR 72.3, where it provides definitions for that section, and it defines an ISFC as an independent spent fuel storage installation, or ISFC, means a complex designed and constructed for the interim storage of spent nuclear fuel, solid reactor-related greater than Class C waste, and other radioactive materials associated with spent fuel and reactor-related greater than Class C waste storage. What part of this definition is not met by the Holtec CISF?
Broadly, Holtec falls within that definition, but this has also been called a monitored retrievable storage facility. The problem is it's far different from what I think the drafters of the ISFSI definition contemplated when they wrote that regulation. I return to my earlier point that we believe that a much higher standard of scrutiny and data inventory and investigation and disclosure has to happen.
Just one point on that. that, Mr. Lott. I mean, there is a procedure in the rules for challenging rules in special circumstances, which sounds to me like that's sort of what you're saying, that you have here a situation, we have a situation that you say was not contemplated when the rule was enacted, therefore there's special circumstances. But you haven't followed that option. That option requires certain requirements in your filings, and very importantly, if we agree, it requires, I believe, immediate referral to the commission. So why have you not followed that route if you feel there are special circumstances that make the rule no longer serving the purpose for which it was promulgated?
Well, Your Honor, the problem is, number one, that is a very complex process. Number two, while we're continuing to look at the possibility of a petition for rulemaking, as I've said, I grudgingly admit that, yes, this is an ISFSI viewed through one prism, but it's not an ISFSI that anyone has ever seen before. And it's much, much larger. It involves a lot of management that is only contemplated and being conceptualized now. So it's difficult to simply say point blank that it violates the rules and get us into the challenging regulation territory. Not quite sure that that's really the appropriate approach. That's the best answer I can give you.
Contention 5 has to do with mineral interest below the site.
Right.
But on page 52 of that, you make reference to chemically aggressive wind-blown dust. What exactly about the dust is chemically active?
The nearby, I think, lakes that periodically sometimes go dry have been dumping grounds for decades, at least back to the late 1960s, for oil and gas and drilling waste, which could contain a lot of acidity, a lot of corrosive material, heavy metals, even radium. And that material is possibly, likely being incorporated into dust, and there are very serious dust storm events in that part of the state. Incidentally, I think, if I'm recalling correctly, that the volume of waste that was being dumped was in the millions of gallons per year over the decades. So there's possibly a great deal of contamination present.
Contention 9, potential transportation routes are not all provided. 10 CFR 72.108 states, the proposed ISFC or MRS must be evaluated with respect to the potential impact on the environment of the transportation of a spent fuel, high-level radioactive waste, or reactor-related greater than Class C waste within the region. And it makes no mention of transportation outside the region of the ISFC. So can you point to anything that requires them to look at transportation throughout the United States?
Well, that is one of the poorest drafted regulations I could imagine, because there's an extensive argument, I think, in either the staff or the Holtec answer, saying, here's how we'll have to define region, since it's not defined within the regulation or within any companion regulations. And my counter to that is, region could mean the 50-mile radius region of influence. It could mean the southwestern geographic region of the United States. Unfortunately, it's a regulation nobody thought to adequately define what region means. And So I think that it is valid to, I think this also, that it may not have been drafted in contemplation of a 20-year or longer massive campaign of thousands of cargoes of spent nuclear fuel. And I believe if that's going to be the reg, that it must be interpreted as liberally as possible, up to and including the, 40 states or so through which nuclear waste will travel to go to Holtec.
Thank you. Contention 10. NEPA evaluation should be performed for operation exceeding 100 years. Now, the continued storage rule kind of says that you don't have to evaluate environmental effects beyond the license period for the current license. So how can we look at that and not consider it a challenge to the continued storage rule?
First of all, we provide some evidence that suggests, even from Holtec, that there may be actually contemplated a 300-year period of operation. It may be a challenge to the GIS, but if you link it to our objections as to the validity of applying the GIS to this situation, this is not comparable to the prototype, the PFS facility, that was actually the prototype in the generic environmental impact statement. This is not, it won't have a DTS, it'll be 4 times the size. There are some other technical differences that are pretty serious distinctions, and we believe that the GIS may not apply, just period, in any type of objective assessment of things. And further, there is the, as I say, the additional, what I consider to be the contract with New Mexico. The original contract between DOE and New Mexico was, if you'll take WIP, we won't do this to you again. And now we see what detrimental reliance will mean when assessing having another possibly DOE-funded facility in New Mexico. So the problem is, Your Honor, I'm not sure that the GIS validly can be construed to have effect here. And if it does, that's a most unfortunate thing for purposes of full and genuine public disclosure.
Okay. On to contention 11. Regulators should consider the risks, impacts, and safety security for the Holtec CISF radiological waste transportation effort. Now, on page 77 of your petition, you discussed the 9th Circuit Court decision in the San Luis Obispo Mothers for Peace case.
Yes.
But on page 4-91 of the GEIS for continued storage, it states, quote, in 2009, the Court of Appeals for the 3rd Circuit upheld the NRC's position that terrorist attacks are too far removed from the natural or expected consequences of agency action to require environmental analysis. Now, this 3rd Circuit Court seems to be more in line with NRC regulations, so why should we be more influenced by the 9th Circuit Court than by the 3rd Circuit Court and NRC policy?
Well, I believe the NRC regulation actually has largely followed, come after the 3rd Circuit decision. It's sort of interesting. The NRC apparently decided to be the Supreme Court and decide which circuit they were going to approve and follow and which they would not. Yet, the 9th Circuit decision is still good and valid and binding in the 5 or 6 states that comprise the 9th Circuit. It's a terrible conundrum. I think it's unfortunate that there is not some type of uniform policy, and I'm troubled by the fact that the NRC did not at least allow the Supreme Court to make a pronouncement instead.
New Mexico is not, for the benefit of people who are not lawyers, New Mexico is not in the Ninth Circuit, correct?
No, but you're correct, Your Honor. But hundreds of shipments will come through the Ninth Circuit en route to New Mexico.
I haven't really formulated a question here. I will have a question for Holtec later about transportation of spent fuel from the jurisdiction of the Ninth Circuit Court. Do you have any comment on that?
I think that the Ninth Circuit law must be respected and abided by within the geographic territory of the Ninth Circuit.
So if Holtec ever wants to take Southern California Edison spent fuel or Diablo Canyon, they've got more work to do.
Correct.
That's the end of my questions.
Judge Figueroa.
Yeah, just some follow-up. You mentioned an RAI that the staff issued fairly recently. What was the date again of that RAI?
About respecting what?
This was with respect to the contention 12 and contention 5 discussion on subsidence.
Oh, I don't know, I haven't seen the response, but the RAI itself was put by the staff to Holtec by a letter dated March 28th, 2018.
Okay, and is there a response or is that pending?
I'm not sure. We think that they may have, the company has approval to respond by the end of February of this year.
Okay. And just one other point, with respect to possible effects of fracking below 5,000 feet,
yes.
Was it your position that that would have an effect on subsidence at the site?
I'm not a geologist. I
understand.
Our concern is
your contention is sort of nebulous.
Our position is that I can't definitively say that it will have an effect on subsidence, but there's some very disturbing evidence in the, you should pardon the expression, region that suggests that it must be examined much more fully. The Permian Basin, they can't get enough workers. They're importing workers from all over the United States, Canada, and Mexico because this is such an oil and gas boom. And it's going to continue into the indefinite future. They can't get enough equipment. They're desperate to construct pipelines to move the product out of the area. This is a huge booming thing. It's not just a passing trend. Thank you. Anything else?
Did you have another question?
I just wanted to finish by saying, so the way you left it was that there are regions in the vicinity of the site that are doing hydraulic fracturing below 5,000 feet and are experiencing subsidence, but there's no scientific correlation of the connection between them.
I think that there's definitely some scientific correlation. I think it's an SMU study that came out approximately, I'm thinking, a year and a little more than a year and a half ago. It certainly does suggest there's a relationship. Fracking, the geological effects of fracking on a large scale type of basis are finally being scientifically understood. And the Permian Basin is providing a lot of experimental data.
Just one final follow-up, Mr. Lodge, on your standing arguments. For your 7 petitioners, am I correct? Do they all base standing on proximity to transportation routes? None of them is within 50 miles of the proposed facility, for example. Is that correct?
I believe it is correct that none of them are within 50 miles. It is not completely accurate to characterize our standing arguments as being solely based on proximity, however. We are also relying to some extent on the actual injury enunciated in the Kojima Stone-Webster decision And there is additionally another NRC site that I cited in our filings. Just give me one moment, please. Yeah, it's a Millstone case. It's a Dominion nuclear case that says that the mere threat of actual injury is sufficient to confer standing. But we believe that we've established in many instances with various declarations from the different putative interveners that they live in many cases within a mile or 2 or 3 of a highway or railroad track that they believe to be a main line. And again, that gets us into the dispute over how could we possibly know or suspect what the main transport arteries will be. But there is proximity, and there is also the possibility, because they live, work, and recreate within a small radius, there is the possibility of direct injury.
What I was going to ask you, I think you just gave the answer. As you know, we tend to follow commission decisions. We sometimes find other board decisions persuasive, and I was just really going to ask you for your best NRC cases. I think you have given them to me, correct?
Yeah, they appear in our written arguments too.
Anybody else? I think for the moment, anyway, we're done. Thank you, Mr. Long. So we have 45 minutes or so today, plenty of time for at least one more petitioner, Mr. Desai, NAC International.
Thank you guys very much for having us. May it please the board, I guess I'll just jump into it for time concerns. If it may please the board, I'm Simon Desai, Counsel for NAC International. I'll start with a general opening statement explaining why we're here and the critical issues with Holtec's universal CISF approach. Robert Bob is available to help us with questions as they come. NEC International is an international supplier of canister, and spent fuel management services to the nuclear industry across the world. We know this industry inside and out, and are involved in the Interim Storage Partners Consolidated Interim Storage Facility project down the road. We're not opposed to Holtec getting a license to a CISF, generally speaking. We think that a Holtec CISF that used Holtec canisters and casks the old-fashioned way would help address the nation's complex challenges with managing spent nuclear fuel. But there is one fundamental issue with Holtec's approach, though, that brings us here today. Holtec's desire to use a universal cask system as the basis for the CISF. They want to take non-Holtec canisters containing spent nuclear fuel and place them in their own Holtec's UMAX canisters at this CISF, without the original equipment manufacturer's consent or assistance. This has never been done before, for good reason, and creates two distinct safety and environmental concerns joined by a single court. We'll get into the scope of the license application and the detailed legal issues during the argument itself. But not to mince words here, Holtec's stated goal for the project is to store non-Holtec canisters, essentially taking ownership of this product. As we stated in our petition at page 8, footnote 8, the Holtec website made the bold assertion as of the petition date, and still maintains that statement as when we last looked, that the high-store CIS will accept a loaded canister in any province, whether they are horizontally stored canisters in Arriva's new home system, or vertical canisters in NEC's system. This is what they're marking. The first page of the transmittal letter to the Holtec's application from March 30th, 2017 states that the high-store UMAX canister system has been engineered to store an entire complement of canisters currently deployed at ISSCs across the country, a technical assertion. And the ER, of course, reiterates this universal concept a couple times, particularly relying on the universal cask system in the alternatives analysis in section 2.411, an assertion the staff agrees is incorrect in its answer to our contentions. And there's more in the reply. Now, with regards to the ER, there's something worth explaining here as it gets to the board's questions and to Holtec's answer. Note that Holtec's language in the ER, which is still maintained, despite Holtec's admission in its answer that it doesn't have an actual universal system, still is there in the ER for 2.411. This is because the ER looks farther out than the specific license application and has a broad purpose and need statement to store SNF from all plants across the country, operating or not. The license requested by Holtec covers just phase 1 of the CISF of 8,700 NTUs. But as described in section 1.3 of the ER aims to cover all impacts during the full 20 phases of the project, 100,000 MTUs and 10,000 canisters. This forces Holtec to have to evaluate now how it will deal with non-Holtec canisters, such as NACs, as part of this environmental report. And because it's being addressed now, NAC won't get a chance to deal with it later. Now, to make this goal happen, Holtec's relying on his universal canister approach, the centerpiece of its proposed CISF, and the ER design alternatives analysis. This approach is a significant departure from the standard reasonable alternatives design in the CISF, in which one vendor, like NAC or Holtec, inserts its own canister into its own cassis. This is the approach that is used in pretty much, or at every ISSC across the country. Even if there's multiple vendors, one will put his own canisters in its own cassis. Now, we actually adopted an alternative, which is the alternative that was in ER 2.4.1, which is the approach at Interim Storage Partners facility down the road. We call it an open vendor approach, in which different vendors can work together to share one SSC space or CI space, but not mixing cats and canisters. This is the reasonable alternative Holtec was alluding to, and then they declined to evaluate in section 2.4.1 of the ER. And we cite to the ISP project petition and amplify this point directly in pages 11 and 12. Now, to note though, we can discuss alternatives in more detail in response to the board's questions or Holtec's answer, but we don't need it for our contention to get in. Simply having an incorrect basis to decline to do an alternatives analysis is sufficient under NEPA regulations, NRC guidance. The NEPA regs, the requirements for the ER tie back to the NRC regulations because 51.45 requires the alternatives analysis, which then goes to the NRC guidance. In addition, there was a point was asked about whether you need proprietary information to do any such alternatives analysis. You don't. There's a whole NEPA consulting industry that's designed to do alternatives analysis and look at things like this. Nuclear power plants have to do alternative analysis comparing to natural gas plants. Actually, PFS had to do alternatives analysis. We cite the PFS. So we mentioned there are reasonable alternatives, but we don't need them for our contention. Now turning back to the statement. There are reasons Holtec's approach to designing a CISF is not standard. Properly storing spent nuclear fuel requires complex analyses of the canister interaction to deal with normal, off-normal, and accident events, such as earthquakes, fires, and droughts. This requires access to proprietary information held by the canister vendor. We described this throughout our petition and through the George Carver affidavit, which is gone unreviewed. And to further drive this point home, we cite to PFS, which had a lengthy second hearing, which was all about whether a canister would rupture in regards to a design basis event. Now, challenging an application before a licensing board is an extreme action, and one we would only do if the circumstances warrant it. We've tried to make our voices heard before in multiple ways. We've discussed with the NRC staff, and both us and Ariva have written letters to the NRC. We draw those to your attention in footnote 27 of the petition. In particular, we wrote to the NRC staff directly challenging Holtec statements in 2.4.1 of the ER, Contention 3, back in August 10th, 2017. We wrote to them at the time that this was misleading. And to this end, we believe the staff has recognized the concerns raised with Holtec's universal CS approach. Turn to footnote 26 of our petition. They've sent requests for information questioning how they can justify adding an Orano canister, for example, to the UMAX system. But with canister, Orano canister. But we haven't seen progress until now, until we've actually gone and done this activity, this filing of intentions, to deal with the marketing. In fact, it's actually Holtec's inability to close the UMAX Amendment 3 process, combined with still marketing the Universal CISF and the Universal UMAX CAS, that leads to confusion about the scope of this application. It was only until we made our stand here that Holtec now admits in its answer that the CIS license, if granted, would not allow storage of NAC canisters at the CISF. And after deferring on our August 10th letter, the NRC staff agrees that our contention about relying on the universal canister is incorrect. So as a result, we've actually made great progress through this proceeding. But until Holtec actually stands down on this claim of a universal CIF system and analyzes an alternative of a non-universal approach, which is the standard for any CISF or SOC, we need to remain involved. Unless Holtec does these two things, The risk exists that an inadequately analyzed Holtec CI7 can store NAC canisters in Holtec's casks at some point in time, and you would be subject to harm from radiological incident or NRC regulations, or the variety of things we talked about in our petition, again, which we're not really responding to in the answers. And to remind the board specifically regarding our environmental contention, Holtec's and the NRC staff's answers that the license application does not consider the universal CIS cask or CIS level, does not apply to the ER. The ER covers impacts across all phases of the project. It's explained in section 1.2 and 1.3. If we don't get our voice in now, a key part of Holtec's path to getting an actual universal CISF and actually getting NAC canisters into Holtec casks at the CISF, the NEPA review and alternatives analysis will have passed without our ability to be involved. On that point, I'll stop my opening statement. Let's get to questions.
Thank you, Mr. Cesar. I have a couple of questions about your position. As I recall, well, I know Holtec opposed, because Holtec opposed the standing of every petition. So Holtec opposed for standing, as did the NRC staff. The NRC staff did not oppose the admissibility of contention 4, I believe. Three.
Environment. Basically, there's 2 safety, one environment.
Three is the one about alternative design.
Yeah.
Okay. And so, both of them, perhaps, made the point that the UMAX CAS system is currently not approved for the NAC canisters, and Holtec is not requesting approval for that in this licensing procedure. So explain to me again why NAC can't wait until Holtec does that. Assuming it does.
Right, assuming it does at some time, but we don't have to remember that because, and regard both on the standing ground, both Holtec's and the NRC's responses are pretty much focused on this issue of we're too early, we have to wait. That's an argument we can get to with the safety contentions. We can get that more detail. But with the environmental contention, which is the one that the staff is not opposed to, does a favor there. The ER purpose and need statement says that we want to take spent nuclear fuel from plants all over the country. To do that, they have to take NAC canisters because NAC is storing spent fuel at power plants that are shut down and in operating facilities all over the country. That's not opposed to point. Section 1.3 of the ER talks about how they're going to fit 10,000 canisters in the CS, and they're evaluating impacts for 10,000 canisters. They can't get there with Holtec. They have to use NAC. We can ask them about how they plan on doing that. So in order to do that, they have to provide an alternative, design alternative, that will accomplish that. So the proposed alternative, they run into this problem actually right now, because the proposed alternative is going to be using this Holtec system. They can only use Holtec system. That, by saying the Holtec system is not universal, they have no actual path to meeting the purpose and need statement at this point in time. But because of the purpose and need statement means they want to use NAC canisters, they're envisioning a universal system, and therefore our canisters will be involved. We can only participate on the NEPA grounds at this point in time. Let's say this proceeding ends, they move to phase 2. They're not going to evaluate the NEPA impacts of phase 2 or later on because they've evaluated here. They've already evaluated the impacts of the facility. They've already said that we have a universal CAS system that can take any canister.
Now, Holtec says, I believe, I hope I'm not misquoting them, but I mean, the staff who filed simultaneously, of course, with Holtec, took the position that yes, there was an inadequate analysis of design alternatives in the ER. Holtec's position is that you haven't made any showing that there are environmental consequences to design alternatives.
That's the materiality.
Pardon?
The materiality, right? The consequences.
The materiality, yeah. Speak to that.
Okay, sure. So, they throw the NEPA book at us, right? You know, the rule of reason, sign a research document, there's only two alternatives. The first, let's look at the legal standard. 72.34 says at the environmental report. It ties back to 5145, says it's an alternative analysis. NEPA regs on alternative analysis say that you have to have a reasonable basis or a description for why you decline to do an alternatives analysis. The new reg 1748, I believe, section 5.2.5 says the same thing. There's also section 5.2.4 that says you have to evaluate any and all reasonable alternatives. But particularly, if you're going to decline to do an alternatives analysis, you have to provide a reason why. Their reason, they disavowed. They said it's not a UMass system. So for a contention of omission, we provided the basis for that. And that's, so by having an incorrect basis to reject doing an alternatives analysis, you're not complying with NRC regulations, because you haven't done the alternatives analysis. You're not complying with New Reg 1748, which gets, staff guiding gets due weight. You're not complying with NEPA regs. So you're having material failure in compliance with NEPA. You can't get NEPA review certified. You can't get your license unless you've met all the requirements of NEPA. And I was actually sent to a decision on Florida Power Rate 75 NRC 615.
Is that in your petition?
No, I don't know if it's in our petition or not, but 75 NRC 615, which basically points out around page 625 that if you find a flaw that gets to being able to complete a Florida NEPA analysis, you have an admissible contention because you've raised a material issue with the adequacy of the NEPA.
Okay. Let me ask a question for the staff. We can have a microphone over there. The staff's position was that NAC has no standing, has not established standing. But nonetheless, the staff agreed that, I may have this wrong number here, agreed that contention 3 would be admissible if they had standing. Now, have you had a chance to look at Holtec's response, which finds neither standing nor an admissible contention? And does that change the staff's view at all?
Sarah Kirkwood for the NRC staff. Yes, we have reviewed the applicant's pleading, and no, at this point, we are not revising our position on the contentions.
Okay. So if in the hypothetical world you agreed they had standing, you would still say contention 3 is admissible?
Yes.
Okay, thank you. If you want to head down this route, part of Holtec's answer gets to that there's no alternative that we should have analyzed. I would like to respond to that and say that, well, we did talk about an alternative. The alternative is what they wrote, using other cask vendors and canisters on the same ISIS. Now remember, we're talking about design alternatives. We're not talking about designs for canisters or casks. We're talking about designs for ISIS. There is a project being built down the road that lets multiple parties come in to work together to put their canisters and their casks on a broad ISIS. Every pad will be designed to allow that to happen. Holtec was the cask and canister vendor in TFS. We cite the TFS in footnote 1. You can look at the EIS for that. They had to evaluate design alternatives. And also, you look at the SER, they only used their own casks and canisters. So that is, they're saying we don't have an alternative. They are the new alternative. They're coming up with this new approach to using a universal cask system. But they declined to analyze the standard approach based on the idea of just having a universal cask system alone, which now they've admitted it doesn't actually exist yet.
Judge Arnold, do you have any questions?
Yes, no question on contentions, but I'm still stuck on standing. I look at the Holtec SAR 4.1.1 spent fuel canisters, and it says the spent nuclear fuel bearing canisters that will be stored in the high store CIS facility are limited to those included in the high storm UMax FSAR. No canister that is not included in the high storm UMax FSAR can be stored in the high store CIS facility. Given that this seems to say explicitly that your canisters would not be used How do you have standing?
There's 2 points on understanding. I'm going to deal with the environmental one, which I've been hitting on.
I don't believe our regulations differentiate between environmental standing and safety standing. It's just standing.
On the contention. So the contention has to be based on what gives us standing. Or at least let's go to the environmental report. So they make this claim that they're not considering NAC canisters at all. How do they get to evaluate the impacts then for storing spent nuclear fuel from all pipelines across the country? How their ER's purpose and need statement has to involve taking Holtec canisters. And that's what they get to in their design alternatives analysis. They say, well, how are we going to get here? How are we going to design a CIS that can do that? One way is to actually take everyone's canisters and casks and put them on our CIS. The other way is to do a universal UMAX, which they use the word universal there. So whenever they use the word universal in their application, they have to be relying on that idea of taking NAC canisters.
Well, wait. Do you infer that the word universal means more than, hey, they would fit in it?
The word universal means they will take canisters of any province. This is what the website says. Well, they'll take canisters of any province, whether these are Rivas canisters or NAC's canisters. That's what their website says.
Well, I'm interested in the application. Websites are notoriously wrong.
Well, you want to claim Holtec's website is wrong, that's totally wrong. But that gets to the definition. We're looking for guidance into what universal means. And so if we have to figure out what the application says about universal, including the environmental report, which is part of the application, they're relying on a system that has to take NAC canisters. So I'm actually challenging Holtec's answer when they say that their application is not considering Holtec NAC canisters, because they're focused just on the licensing report part of it. They say that our application is only for phase 1, but they get to evaluate the impacts for all 20 phases one time, right now, during this application. So if they're going to evaluate all the impacts right now, they have to evaluate the impacts for storing canisters from every type of company, because that's what they're trying to do in the end. That's their purpose in these statements: store it, send nuclear fuel from all plants across the country.
So are you suggesting if this license is approved for only those canisters in the high storm UMAX FSAR, that sometime down the road, without a license amendment, they'll start putting NAC canisters in?
So, turning to the safety contention, they'll possibly get a license amendment. They may not. We'll talk about that in a second. But one thing they will not do during that process is evaluate environmental impacts, because those impacts will have already been evaluated. The CR says that we're evaluating all impacts during the 20 phases of the project, including the design of the CI7. They're finalizing the design for the CI7 now in terms of a NEPA review, because they're analyzing all 20 phases of the project at once. So if they amend later down the road, so they can, add phase 2, add phase 3, and they get their approval to store radiologically that much material, they're not changing the design of the CI7. They don't need to relook at the design of the CI7. They're only doing it once because they wouldn't want to do 20 NEPA reviews.
I heard you suggest that
we can't analyze the design of the CI7 later on. Sorry.
You suggested that a license amendment can happen without an environmental assessment?
The license amendment can happen without an environmental assessment if they've already done the environmental assessment. So for example, the Nuke power plant to do a license renewal, there's a lot of environmental work that's already been done at GEIS for license renewals. A lot of that's already incorporated in the regs. They don't have to analyze that again. So if they've done the environmental review for the design of the facility all at once now, they will just cite to that. They do not have to do, they're going to take the position they don't have to do an environmental review later. And I don't see any response to that argument. I'll get a chance tomorrow, I guess. And to the safety contentions in the licensing report. So our biggest, there's 3 concerns, and you asked, one of the questions was, why is a license amendment process worse than a license process? We've dealt with that environmental report issue. There's 3 issues with waiting on the safety analysis part. One is 72.46 allows the NRC staff to grant a license amendment before allowing for a hearing. Now we've looked at PFS the other time we've licensed one of these things. That was a massive hearing to discuss canister interactions. That would all happen, 10 years would pass, 5 years would pass, a very long period of time would pass. all that time, the amendment is granted first, then Holtec can put NEC canisters in Holtec's casks. And we take all those risks that we were talking about, that we talked about in our contention. And then after that, the thing with spent fuel storage is it's hard to take out canisters from casks. Like, you don't want to do an unnecessary dose. There'll be issues with actually enforcing that process. So that's one thing. We'd be very concerned about the issue of a pre-hearing amendment. Step two, the second issue is the language. Now, we point out a reply, and we can deal with the motion to strike issue if you want to right now. But they have all these technical statements that talk about how they're having a universal capability, how their casks have been engineered to store materials, any canister. So those will stay in this essay. That will become part of the licensing basis for the facility. We will not have had a chance to object to those statements. What we don't want to see happen is down the road, they've tried to incorporate this license amendment. They say, well, we've already discussed this SAI. The licensing basis says in support statements that our cask is big enough or technically sound enough to store any canister in cask. Any canister within its cask. So how do we deal with those statements? This is a unique situation where we have an application that says different things. We have an application that says at one point we have a license condition to only take Holtec canisters right now. And then as part of the ER that says we're evaluating, we have a universal cask system. And then all these other statements. So how do we get a chance to object to those? We've actually, we talked about this in our reply, but we think there would be three things we would need in order to have preserved all our rights. Some sort of, statements in this application cannot be relied upon as a technical basis for proving insertion of a non-Holtec canister into the Holtec cask. We have to make sure we have pre-amendment hearing rights. We have to make sure it's noticed in the Federal Register. The third point is, there are things like administrative license amendments. 7216, the regs do say that they're supposed to notice any amendment. But, every day licenses change RSOs, change phone numbers. This is a low-risk thing, but we are concerned that it could be determined that this is an administrative license amendment because the COC has been amended, and we don't get a right to a hearing. Note that, the only reason we mention this is note the answer. There's no statement actually by Holtec, I believe, and correct me if I'm wrong, that we get hearing rights. They say we get to participate at that point in time. We got to participate through a variety of ways that maybe have no legal bearing. So unless we're willing to say all those things are true, then we don't get the same rights in a license amendment proceeding as we get in a licensing hearing.
This NEPA analysis, which you're claiming is basically covers every other canister on infinitum, what's the basis for your saying that that's what will happen if a license amendment is filed in the future with respect to incorporating NAC canisters into this license?
We're talking about then too the actual statement of the design alternative analysis that relates to the fact that they're relying on the universal canister. Section 1.3 of the ER states that we're analyzing all 20 phases of the project. Section 2.2 I think also gets into this as well. They're saying that this ER, there's other parts of this ER that say this ER is for the final design of the facility. So when they make that final design, they're designing to incorporate only UMAX cask canisters that have to meet the purpose and needs statement.
But your contention too is really saying that's inadequate. You need more information that you don't have to be able to claim universality.
Now, contention two is the safety contention, right? We're talking about the omission, or you're talking about the NEPA contention?
Well, I'm asking, your contention too indicates there's technical information missing. Would that also apply to the environmental report, the NEPA analysis?
So,
could they say we have universality and whatever information they have is adequate? Is that what you're saying? Or are you saying you can't make that universality claim because you don't have certain technical information from us.
So on this safety
On the
petition.
environmental side now. On the safety side, there's no question in my mind that any license amendment would have to reevaluate the safety side. Is that not
On
correct?
the safety side, yes, we would want to believe that license amendment would open the door to reevaluate the safety issues. And if they don't, if they say that they don't, they're going to rely on any part of this application for a later license amendment, then they're not. Then they're actually doing the opposite. And they're saying they're not reevaluating safety issues in the license amendment proceeding. And that's the concern we have that we just talked about with relying, for example, on some of those assertions or statements made in the licensing report later on to avoid doing additional safety analysis. With the environmental review, sorry, you were going to say?
No, go ahead.
With the environmental review, I think this gets to the question, and correct me if I'm wrong, about proprietary information. One of the questions in the list was, do you need proprietary information to do an alternatives analysis? The proprietary information is needed for their alternative, for the proposed alternative. It's needed for them to be able to fit non-Holtec canisters into a Holtec cast. To evaluate alternatives, you don't need any proprietary information at all. And it's a business. I make light of this, but it is a business that you can hire people to do analyses for NEPA. That's the whole industry. And when you look at, for example, they cited the Vogel ESP, so I just picked this one up in page 19 or 20. If you look at the EIS for Vogel, they had to compare the nuclear power plant for the expansion against natural gas plants, against coal plants. They didn't have to call up Massey Coal and ask for proprietary information to do that analysis. Now, they can go as far as is reasonable. Instead of relying on this universal cast that they've now said doesn't exist. Instead, what if they had said the alternative analysis? We looked at it this far, and this is what we can come up with based on our analysis. That might be going as far as is necessary, but they haven't done that. And they can't just assert near the end of their answer that proprietary information might be needed to evaluate alternatives. They have to actually do that as part of the NEPA process. Otherwise, they get a chance to rehabilitate their ER through the answer, which doesn't satisfy the requirements of NEPA.
And if a license amendment is requested in the future, this contention you're filing now would not be valid?
The environmental contention would not be valid. So an environmental, if they filed the license amendment request in the future, and we said you should evaluate an alternative design to the CISF, they would say, wait, we evaluated the design of the CISF right now, all 20 phases in this ER, which then becomes an EIS. And so we've already evaluated, you're out of time. This is the bind we're into with this misleading marketing too. We have to be present at every phase to avoid that from happening. And the ER is a very present risk because they've already said they're evaluating all 20 phases of this project now.
And what you're looking for is for Holtec to work with you in the same manner as the interim storage partners?
We're just looking for contention and admissibility. We're looking to make, a broader scope, and we can get to
That's the end. Whenever you have contention admitted, you're looking for some judgment. I don't understand what it is.
We had a contention admitted, pointing out a material flaw in the NEPA analysis. We have a hearing to determine the scope of the material flaw, the correction to the material flaw, and to make sure we get our voice heard as to the extent they're going to rely on a universal cast system. So they say they're going to rely on a universal cast system. That's kind of the foundation of what we're opposed to, because the universal cast system is going to use NRC canisters. If they're going to rely on that universal cast system, we should get a contention in that allows us to go to a hearing and really evaluate whether that universal cast system can be relied upon for the ER. This is the only chance we're going to get to do that. And the part of that might involve evaluating alternative analyses. But that's for the hearing. And to get the contention, we just have to show that they had material a material flaw with meeting the requirements of NEPA and failing to meet 40 CFR 1502.14a, which is the requirement that you provide a basis for rejecting to do design alternatives, is a material flaw.
Does the staff agree with your reading of all this?
Well, staff did not object to our contention to admissibility. They agreed that we pointed out something that was incorrect in the ER. They agreed that we could get a contention on that, so we would get the hearing to evaluate that statement.
With respect to loss of NEPA rights?
With respect to, yeah, the NEPA issue.
Staff agrees with your reading that NEPA rights will be lost in the future.
The staff does not agree to standing, and one of the arguments they make is that the CISF, or it's basically the same argument Holtec has made, which is that we're not contemplating a universal CISF at this point. To which our response is, they are for the ER part of this at the very least. And for the safety, we have this argument about all the statements they make in their application. But particularly the ER, it's a much simpler point. They are contemplating universal CISF because they have to, because their ERs for the final design of the facility.
The key for me is why there would not necessarily be an ER amendment in the if a license amendment is filed.
So the license amendment, let's see what that would cover. The license amendment would say that the license amendment is to incorporate the COC. The COC would say, or the amendment to the COC, let's say we permit a canister of Arriva NAC into UMass gas. That is the basis of this amendment. And so we'd be able to challenge whether that's accurate on a safety grounds, whether that might result in some other impact. But the alternative design of the facility will have already been set. Because this ER is 20 phases long. It's just setting the design for the facility. So later, if we have an amendment proceeding to deal with this COC amendment, we'll get to talk about the NEPA issues related to that COC amendment. But we won't get to talk about the alternative designs of the facility. You'll tell us, too, that we should have done that when the design of the facility was actually up for bat, which is at this point in time.
It seems to me that what I'm hearing you say in part is that you're here today because if you're not here today, you won't be heard tomorrow. And on that issue, plus generally this contention or this petition, I'd be very much interested in Holtec's response, which Mr. Silberg, at your option, you could address now or tomorrow when we get to you. Which do you prefer?
If you could state the question,
I mean, what I'm hearing a lot here is that NAC is in this proceeding today because they're concerned about events that may or may be likely to happen in the future, and that they will be prejudiced in their ability to deal with those events in the future if they aren't here today filing this contempt. Is that, Mr. Desai, is that a somewhat accurate statement on the environmental side?
And I would add that we're responding to, in essence, their counter, right? We've said in our petition, this is, they're licensing and dealing with the environmental impact of the universal CISF now. They're responding and saying, no, it's not a universal CISF right now. To which our response is, they're dealing with these universal CISF issues now. Okay. So.
And Mr. Silver, do you want to respond to that now or tomorrow?
Tomorrow. I think the answer is, we think that's incorrect, but we'll have a fulsome answer.
Okay. Well, we'll make a point of asking you that tomorrow. Yeah, I think rather than begin with Baskin with only less than 10 minutes left, we will call it a day today. We'll begin at 9 a.m. tomorrow. Thank you. begin at 9 a.m. tomorrow with either briefly the representative from the city of Carlsbad or Baskin, Mr. I. And then we will get to Holtec and the staff. And I think I think there's a good chance we will finish by lunchtime. We will see how many questions we have for you. So that is it for today. We'll see you all.